Okay. For this gentleman? Oh, yeah, I did.
Oh, okay, see, yeah, he's here.
So Mr. Budrum is here now? Okay, so we're switching for Mr. Budrum. Okay. All right. Put this back over here. Okay, so we're going to call up, Mr. Budrum has a number of cases, actually.
Your Honor, excuse me, Mr. Boudreaux has appeared, so
Right.
he is standing to my left.
I hear that, but I want to tell the court reporter some of the case numbers, okay? We have a violation of probation, 2019 CF 12475. We have a number of out-of-county warrants, and then the new charge, I think is, wait a minute. Um, Find it. Do we have a new case number, or we just filed this under a VOP? Okay, so the new case,
Yes, Your Honor, I do believe there is a new case number for the out-of-county warrant from Osceola.
is that the,
The 5582 case number.
okay. All right, there's a few things. I say, Mr. LaFay, I read the paperwork, and I assume you want to make some arguments.
I do, Your Honor. Your Honor, Mr. Boudreaux, of course, has what I can only call a slew of Osceola County charges. And of course, he's bondable or entitled to a bond on all of those, but that's for Osceola County. He does currently have a no bond, I believe, on a felony attempted possession of a controlled substance. Attempted possession, although a low-level felony, is still a felony. Even with my recollection of the score sheet, is even if we added X points on the score sheet, Mr. Boudreaux would not score prison. My recollection is that the violation of probation, that count, the adjudication for attempted possession of a controlled substance, is his only prior record, but I'm just going on my recollection, and I don't know if the state has anything to correct that or not. I can do some testimony. Mr. Boudreaux has been on probation, I'm going to say, for 7 months out of a 2-year term. And he was arrested, in fact, I think the warrant would bear out, he was actually reporting to probation when he was arrested. Otherwise, I'd just deduce some testimony from Mr. Boudreaux about the amount of time he's lived in the community and his ties to the community.
I have to tell you, Mr. LaFay, he's gotten himself pretty well situated as far as the number of charges and the probation. I appreciate the fact that you're here and you want to take the testimony, but the truth is, there's not much I can do. I mean, with the violation of probation and the out-of-county warrants, I think, to be honest with you, I could let you do whatever you want to do here, but you're basically going to have to go to those trial judges and the probation judge and figure out what you can do for this young man. It'll be an interesting case.
Thank you, Your Honor.
I mean, if it was legal, the guy would be rich, right? He's obviously got a fine work ethic. But, I can't
Perhaps
fix the situation for him right now.
perhaps a misguided work ethic, but thank you, Your Honor.
Yeah, I mean,
So
he,
in that case,
if it were legal, he'd be successful.
I'll just rest on my arguments previously made.
Yeah. Sir, you've given your lawyer quite an interesting job to try to help you out. I'm sorry, it's just not legal. You really, if you get a chance, you should pick a legal way of making a living. You'd probably be successful.
Yes, ma'am.
The state wants to say something too?
Yes, Your Honor, just briefly in response, since it is an out-of-county warrant and PC has already been found, state just asks that you stay the bonds as previously set on that case. And in regards to the VOP, since he's not entitled to a bond, state just asks that you hold him no bond on that, pending a VOP status in front of Judge Lattimore.
Yeah.
I believe also there was an issue regarding the case number on this case. It was brought to my attention by Madam Clerk. On the 21 CF 5582, his out-of-county warrant. It is an Osceola case. I believe it was given an orange case number.
That's a good question. Is that something the clerk's going to remedy, or?
If we could just retire that case, the Orange County case number on the new offenses, because it's an Osceola County case.
Do we need a court order to do that? If we do, then I'm glad to do that. And then I guess he gets first appearance over in Osceola County then.
Correct, Your Honor.
Okay. So I think the state's recommendation is a fair one at this point, that we just leave it at no bond on the Osceola, the VOP. And right at the moment, stay the amounts on the Osceola charges and let Mr. LaFay make his best effort over there, I guess.
Thank you, Your Honor.
You're welcome.
Good to see you, Your Honor.
It's really nice to see you too, and good luck to you.
Thank you.
On this.
That's staying the bonds on all 11 counts, Your Honor.
Yes, ma'am. Okay, is this Mr. Brenton?
Yes, ma'am.
Thank you. I know I saw you before, but I sidetracked there. Okay, so what we have is I guess, a violation of probation warrant on a domestic battery in county court, 2020 MM 4400AO. And actually 2020 CF 11554AO, in which it's alleged that you had contact with Ms. Bolden, who was a victim in a domestic violence case, as well as in 20 MM 4400, basically the same thing. So I guess a couple of violations of probation on two different charges in regard to having contact. And, sir, at the moment, these are set, misdemeanor in Division 50, and the felony, they're both set at no bond, which is very common for violations of probation. We'll appoint the public defender, and it is my expectation that you'll be in court fairly quickly in regard to those. There's just not much I can do right at the moment, other than appoint the public defender for you. Right.
Judge,
Good luck, sir.
can I talk to you for a second?
Is this Mr. Bryan?
Yes, ma'am.
Okay, thank you, sir. Okay. We have the new case number 21 CF 5781AO going to Division 12. We can appoint the public defender to represent you, sir. And the allegations are aggravated assault with a firearm and also battery.
Your Honor, in regards to this case, I believe that the way the officer charged it, it came in as ag assault with a firearm on a code inspector. There is no allegations in the affidavit of the victim being a code inspector. I believe the officer just chose the wrong statute. State would just ask that you find PC to 784-021, sub 1, sub A, which is this aggravated assault with a deadly weapon, which, and then in 775-087 is the sentencing options regarding the firearm. As it is a lesser included, you can find PC for that 784-021, since there is no allegation that the victim is a code inspector.
There is an allegation?
There is not, Your Honor.
No, okay, all right. So you just want the paperwork to be amended that it's .021 subsection 1A.
Yes, Your Honor.
That's fine. So ordered. So, sir, we don't do too much here, but you do qualify for the public defender. That's the first and most important thing. It appears that they had probable cause for the charges to at least be filed, even though they never found the gun. That's something that you'll talk to your lawyer about. And I was going to set bond, I'm a little bit concerned that you have in your past fleeing and attempting to elude, and also Georgia's not going to extradite, but evidently there's a warrant for failure to appear over there, and so I was willing to set bond initially on the kind of look at it together, really, but we'll call it an aggravated assault with a firearm at $2,500, realizing they didn't find the gun and that you deny that. But, and then 150 on the domestic battery by strangulation. So we've got some bonds on that. I understand that you have a 9-year relationship. I can't remember if you were living together or not. If she's not here, oh, you weren't living together, you're trying to get your trucks out of the backyard. So no contact while you're out on bond, unless a judge hears from both parties and determines that it's safe. I don't think you need, in order to get, do you still need to get your trucks out of there?
I got to move yesterday.
Okay, so, if you have any guns, knives, or
Sorry,
what,
in that case, we'd ask for a no return to her residence.
no return to her residence. If you have any guns, knives, weapons, put them in the custody of the arresting agency within 24 hours of your release. You're not allowed to have weapons while you're out on bond for this. Now, the other thing was that you might have been out on bond for fleeing and attempting to elude, and it is a violation of release conditions to get rearrested. But I'll say this, counsel, I took that into consideration in setting the bond on this case, given all the facts and circumstances.
Thank you.
So I'm not going to take any action on the out on bond. Now, that's a little bit unusual. Normally, I'm going to at least double it. Some people, will revoke your bond on that. So I just made an adjustment.
Thank you, Your Honor.
Your Honor, just for the record, state would ask that you do revoke and either set a higher bond or leave him at no bond. It is alleged that he went to her home, cocked the gun, hold her by her neck, and placed the gun to her head.
That's it.
We'll talk about it.
Yeah. Normally,
It's just an incredibly violent offense, and he has previous DV battery arrests. So just for the record, state would object and would ask that you at least revoke his out-of-bond cases.
I understand what you're saying, and it's reasonable, and normally I would. I guess I go by my instincts to some degree, after about 40 years of dealing with this stuff. And so what, I'm reacting a little bit to is, why did she have the trucks in the back? Why didn't, she just let it happen? The gun wasn't found, so I don't really know. What I did was I just sort of adjusted it in terms of the $2,500. He's going to have to post a bond. Hopefully that bondsman is going to make sure he's coming back to court, although I have a concern because the one case was a fleeing and attempting to elude, and he's got a traffic charge that he didn't deal with in Georgia. So a little bit of a concern about him going back, but also looking at all the facts and circumstances. So I gave him a little bit of credit for some of that, but That's my best guess at this time, sir. You do need to come back to court, and obviously, you don't have any more slack left, so you need to leave her out of the picture and do everything correct while these cases are pending. You're starting to get a bit of a history. And I don't know what's going to happen with the gun allegation. If I thought for sure, if they'd found that gun, if I thought for sure you'd done that, I just have left you in jail. Just, do not pass go. You don't get out. All right, good luck. All right, is this Mr. Dela Cruz?
Yes.
Okay, thank you, sir. We have case number 2021 CF5760. And the allegation is aggravated battery with a weapon on this situation being an air freshener can, but she did get a couple of stitches in the front of her face, I think. And I guess she's here to testify?
I need the person.
She needs an interpreter. Okay.
Good morning, Your Honor. This is Laura Arroyo, State Certified Interpreter, already previously sworn.
Thank you very much. We have a testifying witness here, and I will ask her, ma'am, could you raise your right hand to be sworn in to tell the truth?
Señora, por favor, levante la mano derecha para prestar juramento y decir la verdad.
Juro decir toda la verdad.
¿Cómo?
¿Qué tengo que decir?
What do I have to say?
Do you swear to tell the truth?
¿Jura usted de decir la verdad?
Sí, lo juro.
Yes, I do.
Thank you. You may put your hand down.
Muchas gracias. Ya puede bajar la mano.
And we are all very old, and so we need for you to speak up.
Nosotros ya somos un poco ancianos, así que por favor le pedimos que hable alto.
Ok.
Okay.
The prosecuting lawyer wants to ask you some questions.
La fiscal quiere hacerle a usted unas preguntas.
Ok.
Okay.
Good morning, ma'am. Can you state your name and spell your last name for the record?
Buenos días, señora. ¿Podría usted indicar su nombre y deletrear el apellido para el acta?
Keshmari Pérez.
Yes, Marie Perez.
And what is your relationship to Mr. Dela Cruz?
¿Cuál es la relación que tiene usted con el señor de la Cruz?
Es pareja. Es boyfriend.
We're partners. He's my boyfriend.
Approximately how long have you known him?
Aproximadamente, ¿hace cuánto tiempo que lo conoce usted?
Casi vamos a cumplir un año ahora en junio.
In June, it's going to be 1 year.
Has anything like this ever happened before?
¿Acaso algo semejante a esto ha ocurrido alguna vez en el pasado?
No.
No.
Are you afraid of him?
¿Usted le tiene miedo a él?
No.
No.
If you were to be released from jail today, would you be afraid of him?
Si él fuera a ser puesto en libertad, ¿le tendría usted miedo?
No.
No.
Do you want to have contact with him?
¿Usted desea tener contacto con él?
No. Prefiero tener una orden de alejamiento.
No, I'd rather have an injunction.
Okay. Well, we're not able to do that at this time. However, you can look into that at the clerk's office downtown.
Muy bien, eso no se puede hacer en este momento dado, pero es algo que usted podrá mirar a ver con la secretaría del juzgado en el centro de la ciudad.
Ok.
Do you believe,
Okay.
do you believe drugs or alcohol played a part in this incident?
¿Usted considera que en este incidente hubo drogas y alcohol?
No.
No.
And lastly, are you willing to call 911 if anything like this ever happens in the future?
Y por último, ¿usted estaría dispuesta de marcar al 911 si algo semejante a esto fuera a ocurrir en el futuro?
Sí.
Yes.
That's all I have, Your Honor.
Eso es todo, Su Señoría.
Okay. I just want to note that we'll appoint a public defender to represent him. And
Quiero
ma'am,
que sepa que le vamos a designar a él un defensor público.
Ma'am, I have one question. Mr. De La Cruz evidently meets the criteria to be let out without posting a bond amount.
Le tengo una pregunta que hacer, señora. Parece ser que el señor de la Cruz cumple con el criterio de ser permitido libertad sin tener que depositar fianza.
Assuming that I would order no contact with you, are you, and I understand you live near each other, will you feel safe if he just gets let out while on pretrial release?
Y vamos a decir que yo emita una orden donde se le prohíbe a él tener ningún tipo de contacto con usted. Y tengo entendido que ustedes viven cerca uno del otro. Y entonces, si se le fuera a conceder a él libertad provisional sin fianza, ¿se sentiría usted segura y a salvo?
Sí.
Yes.
Okay, thank you.
Muy bien, gracias.
Gracias.
Anything
Thank you.
else?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
Okay. So, according to his relative lack of criminal history, he meets the requirements to be allowed out without posting a financial requirement to post bail. Sir, you would have some requirements and conditions that you would need to meet. The first one is no contact with the young lady. Even though you live near each other, you have to avoid each other's presence, okay? If you see her, just look the other way and go to your car or your house. If you have any guns, knives, or weapons, those have to be surrendered to the arresting agency within 24 hours because you're not allowed to have weapons when you're out on bond for this. Make sure you appear at all your court dates, and you probably should call your public defender because, that's the way they can represent you.
Your Honor, are you going to order separate residences or a no return?
Oh, they have separate residences.
Then I'd ask for a no return to the victim's residence.
Don't return to her house. And it's Division 20, counsel. I think that's all.
You want the interpreter to translate that?
Yes, that's a lot. I'm so sorry.
No, it's okay, I have it. Muy bien, señor. Entonces, según la falta de historial, usted podrá ser permitido libertad sin tener que depositar una caución monetaria. Pero, señor, la libertad sería con ciertos requisitos y condiciones. Usted estaría, número 1, prohibido de tener ningún tipo de contacto. Tendrían que evitarse uno el otro, aunque yo entiendo que viven cerca uno del otro. Por lo tanto, si usted está circulando y la ve y se encuentra con ella, aléjese, métase en su casa, vuelva a montarse en su carro. También está usted prohibido la tenencia de armas. Si usted es dueño de algún arma, tiene que entregárselo a la agencia que le arrestó dentro de un plazo de 24 horas una vez que se ha puesto en libertad. Eso forma parte de la condición de su libertad. Y tiene que comparecer a cada vista que se va a celebrar en la causa. Marca usted, por favor, el defensor público que le esté representando y sepa que está prohibido regresar al lugar, a la vivienda, o sea, donde ella vive.
Thank you. That was excellent.
You're welcome, Your Honor. May I have the case number for this gentleman if we're finished?
Yes. It's 2021 CF 5760AO.
Thank you, Your Honor.
Thank you.
Is the interpreter needed for anything else?
That was it. It was just victim testimony. Thank you so much.
Okay, you're welcome. Bye-bye.
Okay, is this Ms. Lewis Langston?
Yes, ma'am.
Okay, ma'am. All right, we have a case. No, I don't see any witnesses. Let me read the case number is 21CF5785AO, Division 22. And we can appoint the public defender to represent you, ma'am. Now, there was probable cause for the charges of possession of controlled substance, possession of cocaine, count 2, and count 3 battery. In regard to the battery, ma'am, since your husband isn't here at the moment, we have to have his testimony before we allow contact. So you'll contact your public defender as soon as possible in order to have them set up a hearing if you need to have contact. I think you all are living together, and so that,
I was trying to leave.
you don't have to say anything about your case. I would mention to you that your lawyer wants for you to talk to them first so that they can prevent you from making any accidental admissions about your case. It gives them more power to negotiate a favorable disposition if the state doesn't have the case partly proved already, okay? That's just a strategic thing. So, so at the moment, it has to be no contact and separate residence. If you've got things in the residence, you can have a police escort to get your things out until you get that hearing in front of the judge. And I could think you're telling me you want to leave anyway, which is fine. But for now, we try to keep it all safe by keeping you apart until we hear that it's safe from both parties. And I wasn't, it's a misdemeanor battery, it's just the typical thing. And in regard to the drug charges, they had probable cause. I'm not used to the bonds. I'm not sure if they made the bonds a little bit higher because they're not sure where she lives. I might be persuaded to adjust those bonds down a little bit.
Thank you.
Although it says that there's a high risk because she lives between Florida and South Carolina, I'm not seeing a bunch of problems in regard to failures to appear. So, anybody want to say anything, or you want me to just set the bonds?
No, Your Honor, I'll leave it within your discretion as it's only a drug charge.
Okay, all right. Maybe my information is old from my past experience, but I would go with 1,000 on the count 1 drug possession, 150 on count 2 cocaine possession, and 100 on the battery charge. Not to minimize anything, ma'am, but we try not to keep people in. We just try to get them back to court.
Your Honor, state would ask for a condition of no drugs or alcohol without a valid prescription.
I'm sorry, I'm old, I can't hear you.
State would ask for condition of no drugs or alcohol without a valid prescription.
Oh, okay, yes. It's real common for them to ask is that you don't have any drugs or alcohol that are unprescribed while you're on a bond for a drug charge. And also, it's normal for them to ask and for us to require that if you have any guns, knives, weapons, you put them in the custody of the arresting agency within 24 hours of your release because of the battery charge. Right? Those are just standard. They'll be on your paperwork. Good luck, ma'am. Okay, is it Masikot?
Yes, ma'am.
Okay, thank you. What we have here. It's case number 2021-CF578680, Division 10. And we will appoint the public defender to represent you, sir. I'm not seeing any witness here. And they have enough information to file the charges, at least on the battery and the false imprisonment. Since the alleged victim is not here, we're going to order no contact and separate residence unless and until you get back into court and the judge hears from both parties and determines that it's safe. The way you get that done is you talk to your public defender about it, who can get that hearing set up fairly quickly, I believe. And if you need a police escort to get some things out of her, what used to be your shared residence, you can have that. And I do see some prior history. I can set a bond unless anybody wants to say anything. All right, sir, I think the biggest problem is the prior history, and I hope that you understand if there's any other calls to the police office in regard to this relationship, you're probably going to be bonded on these. But in the interest of the presumption of innocence, I'll set bond on the false imprisonment at $1,500 and the battery at $100. Assuming and expecting that you'll comply with the other requirements. I'm not sure if I said yet that if you have any guns, knives, or weapons, put those in the custody of the arresting agency within 24 hours of your release. You're not allowed to have any weapons while you're out on bond for a domestic case.
Yes, ma'am.
All right? Make sure you call your lawyer and come back to court for all your court dates. Okay, and this would be Ms. Ravello? Okay, ma'am. I think this is 2002-1 CF 5740. And we do have a witness here, sir. Let's get you sworn in 1 moment. Ma'am, I'm looking at the public defender form, and it says that you make $850 per week. If you do, then you're wealthy enough to not get the public defender right now, but you can always come back to court and advise the judge if you're having trouble getting a lawyer, because it's important that you're represented, okay?
Yes, ma'am.
All right, sir, do you swear to tell the truth, the whole truth, and nothing but the truth?
Nothing but the truth, ma'am.
All right, thank you. You can put your hand down. And we need your name for the record.
Mario Anthony Ravello.
Okay. Now, the state wants to ask you some questions about whether or not you want contact and the circumstances.
Ma'am, may I speak?
The state just likes to ask you the questions, if you don't mind. She's going to ask them anyway, so let's just do it once instead of twice.
Good morning, sir. Can you please state your relationship to Miss Ravello?
She's my wife.
Are you afraid of her?
Not at all.
Would you be afraid if she were to be released from custody?
Not at all.
Do you want to have contact with her?
Contact with her is what would keep me from having to go to a crisis unit. Yesterday morning, around 4:45 approximately, I was experiencing a night tremor, and that's something that happens with me every once in a while.
You experienced a what?
Night tremor,
A night tremor.
and she's the one that holds me and tells me everything's okay, and everything's okay, and she gets me through it.
Okay.
Now, that happened around 4:49. I remember seeing the clock before I kind of realized a little bit what was going on. And she said, "Okay, you okay?" And I said, "I'm okay, baby." So I went to the kitchen, and I continued to slip into a manic episode where I was hitting myself.
Let me interrupt you, sir. I know this is really important, but I think you're going to ask the state to drop the charge right now, and they won't do it right now.
I understand that, man.
We can let her out, we can give you contact, but you're going to have to go to a couple court dates before you get your story really told.
Okay.
But if you want, what I'm hearing you say is you want
She
contact.
saved my life. She saved my life yesterday morning. When I got to the point where she had taken the plates that I hit myself with, and I looked and I got a knife, and I even attempted self-mutilation. She disarmed me,
Okay,
and I don't know what.
all right, well, you need to
When
get
I
some
ran
help,
out of the house,
you
I don't
know.
know what I told the authorities. But
All
what I
right.
meant to say was, I don't know what's going on. Help! I'm sorry. Is my wife okay?
All right, okay.
Okay, sir. So you would like to have contact with your wife?
Yes, please, as soon as possible. If not, I'm gonna have to go to voluntarily Baker Act myself.
That's all I have, Your Honor.
Okay. All right, well, so let's go with pretrial release. She's eligible. And what we put down on the paperwork, folks, is no hostile contact. So, you know, if something happened again and the police came out, they would see that Mrs. Ravella's out on bond for this, and there's not supposed to be any hostile contact.
Your Honor, sorry to cut. Would you consider ROR her? Because I'm just now getting myself back together, and posting bonds gonna take some time. Would you consider an ROR for her?
Well, PTR is almost that, except that she just reports to these people.
Okay.
What's the state's response on that?
Your Honor, she doesn't qualify for ROR due to the nature of the charges, that they're violent in nature and it's domestic in nature.
All right. It's easier for us to PTR right now, and then the best thing for you all to do, I think, is just to get you some help as soon as possible.
She's
Because-
scheduled, she got me to a point where I agreed to go talk to a psychotherapist. I tried in the past, and it set me back to a point where I was like,
Okay, well,
7 years old in my
sir,
mind, so.
You know, welcome to the human race. I think everybody needs to talk to a counselor periodically. It's like, to me, it's like flossing your teeth, you know, it's getting rid of the cobwebs, okay? So you guys are about the age where it's really time, midlife, you know, so just go, stop fighting it, things are getting out of control, but we're gonna pre-trial release her, that means you have to report these guys, and they're gonna tell you what the requirements are. No hostile contact, so just, you know, try to keep it sane so you don't have police come out, because they're not gonna understand what he's just said, okay? If you have any guns, knives, or weapons that are not like kitchen knives, put those in the custody of the arresting offices within 24 hours, because we're supposed to require that. And I don't think we need anything else on this one, sir. Just get yourself some, you know, there's no shame in getting counseling.
Yes, ma'am, thank you.
You're welcome. Okay, is this, what happened to Ms. Whitlock? Did she, can't come to court?
Isn't that after me?
She's next. Oh, did I forget? So I forgot Mr. Sawyer. Okay. Thank you. I didn't forget you, I just skipped down the line. Oh, all right. Okay, so Mr. Sawyer's actually first. I'm sorry, sir, I just looked at the wrong line on the page. Okay. We don't have a witness here. It's 21 CF 578780, Division 20. And Mr. Sawyer, you do qualify for the public defender's representation, so you can have a lawyer on your case. And the allegation includes battery with one prior, false imprisonment, and witness tampering. They had enough information to file the charges. Since the wife is not here, we're going to order no contact until a judge hears from both sides and can tell that it's safe. Now, evidently, there might have been a child present, so The state's going to ask for no contact at the moment. However, what I would say is we would follow any orders by the juvenile court. Generally speaking, no contact until authorized by juvenile court or trial judge. They're going to report it to the Department of Children and Family Services if a child saw domestic violence, and then they may make some orders, and the orders here are supposed to follow what happens over there. But just be careful with 2 cases going on. Make sure you understand the paperwork at all times.
Your Honor, just to be clear, the no contact is with the victim, which is the wife.
Is what?
The no contact is with the wife, Heather Sawyer, or
With a
Audra
wife,
Sawyer.
and with the child, I anticipate you're going to ask for us to follow the juvenile court orders.
Yes, Your Honor, okay.
Right, because it is assumed that if a child sees domestic violence, that there's potential harm to the child, so they're probably going to create a case over there. Okay?
My daughter's.
You don't have to say, your lawyer's going to tell you not to talk to me because she's afraid you might actually confess something.
Thank you, Your Honor.
Okay, and so I'm willing to set bonds on these, just to tell you to come back to court, and with the no contact orders, should keep everything safe for now. Talk to your public defender if you want to have contact. Separate residence, right now, I don't, determine who gets to stay in the house, but if you need a police escort to get some things out in order to abide by the court orders of no contact and separate residence, you can have a police escort to get your things out. And then, you all ready for me to set bonds, since you think I'm pretty normal? Okay.
So no weapons? order, Your
No,
Honor?
yeah, if you have any guns, knives, or weapons, you're not allowed to have any while the case is pending, so we would tell you to put those in the custody of the arresting agency within 24 hours of your release. A little bit concerned about priors, sir, but willing to set bond at $1,500 on the false imprisonment, count 2. 150 on the count 1 battery with 1 prior, and 150 on the count 3 tampering with a witness. So you can post the bonds, get your stuff out of the house, talk to your public defender, be real careful about contact with a child in relation to what the juvenile court says.
Your Honor, state would ask for a higher bond, given that he does have a prior history of batteries. I don't believe the 150 is reasonable, given his priors, and recent priors at that.
Yeah, I think what I was going on, that's a reasonable request, sir, and I understand it. I was just going on it. I think the most aggravating situation in the context is that she's disabled. And that, really could cause me to react and make it a higher bond. But there's a lot of concern about the presumption of innocence and the cash bond system and all, so I'll stay with the 1,500, but she's making a reasonable request. And the other thing you should read from that is, the more you get on your criminal history, prosecutor's going to see it, judge is going to see it. You do get to the point where you've just tripped the wire and it's really hard to get out, and you're getting closer to that. So don't have any drama while the case is pending. Any drama and you'll be right back here. And you might not be able to get out. All right, good luck. Okay, is this Miss Whitlock? Yes. Okay. All right, so we have a witness here. Let me first go ahead and appoint the public defender in regard to 21 CF 5754 and 2010 MM 475A. Sir, would you raise your right hand to be sworn in? Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. And the misdemeanor is, it's an old case, supposedly a failure to appear. What's the name of it? On a petty theft case. And I think the order was 2,000 and home confinement.
Yeah, Your Honor, in reference to that warrant, we just asked if you could strike home confinement from the warrant as we don't.
Because we don't really even have those anymore. Right, okay, so I think that's a fair situation also because she's going to have to come to court on this other thing anyway, so I'll do that. It's an old case, ma'am, and you're going to have another court case date on that in a separate court in Division 62, and we're appointing a public defender on that. An old petty theft. Now, the state wants to ask our witness some questions, sir. You've been sworn in. I'm going to let her ask you some questions.
Has he already been sworn in, Your Honor?
Yes, ma'am.
Good morning, sir. Can you please state your name for the record?
Justin Shipman,
And what is your relationship to Miss Whitlock?
spouse.
Do you want to have contact with her?
Sure.
Can you answer out loud,
Yes.
please? Thank you. Are you afraid of her?
No,
Has anything like this ever happened before?
no,
If anything like this ever happened in the future, would you feel comfortable calling 911?
yes,
And do you believe drugs or alcohol played a part in this incident?
no.
That's all I have, Your Honor.
Okay. All right, then, and public defender's appointed, so go ahead and get in touch with them as soon as possible. Now, she evidently meets ironically, meets PTR notwithstanding the outstanding case. And I'm not, used to doing that when there's a knife involved, but I understand the circumstances where he's not concerned about it, and you don't have to say anything about the case, ma'am, but supposedly said she wasn't intentional, that she was swinging the knife in anger, so I could live with pretrial release, even though that's really strange for me when a knife is involved, but those, I think, it's the way it scores out here.
It's generally my understanding when she does have an open case, PTR is not an option. If Miss Davis,
Yeah, that's different. I'm not used to it, but I, am understanding that things are a little different now than they used to be.
yes, Your Honor. However, if she otherwise qualifies, state has no objection given the victim's testimony here today and that she
Right.
otherwise qualifies.
Okay. Okay, so we're going to find that there's enough information for the charge to be filed, but let her be released on pretrial release program. She's got to bond on the old case because it's a failure to appear, and so that's 2,000. In regard to the domestic charge, we're going to put no hostile contact. That means, I don't know if she's listening because she's talking to her lawyer too. In no drama while you're out. Any drama, the police officer's going to see both of these cases, and you're just going to be right back here, and it probably not be easier to get out at that point. Okay?
Yes.
All right. If you have any guns, knives, or weapons, I don't know if this was a kitchen knife case, because I had a couple of those today. If you have any non-kitchen knife cases or guns or weapons, put those in the custody of the arresting agency within 24 hours of your release. That's a standard requirement. Anything else that I missed?
And
No,
for the
Your
record, you did strike the home confinement?
We struck the home confinement from the failure to appear warrant, but that's a $2,000 bond. You need to make all your court dates and talk to your public defender if you want a reasonable chance of being represented.
Thank you.
Good luck to you both. Okay. I think this is,
Alan Ibarra.
oh wait,
Excuse me?
sir?
What's up?
We just finished the felonies, right?
Yes, Your Honor. This is misdemeanor DV.
Okay, thank you so much. Just took me a second. Is this Mr. Ibarra?
Mhm.
Okay, thank you. All right, I think we have case number 2021MM191AA. It's going to a Division 50, which is a court where they only deal with the domestic cases. And you do qualify for representation by the public defender. So, your dad's not here at the moment, sir, in which case, until we hear from your dad in court with sworn testimony, we have to require no contact and also separate residence. I think if I recall correctly that you're living with your dad at the moment, but we're going to need to give you a police escort to get some things out of the house, so, and you can live with some other relative for the moment until you can get in front of the judge, and the judge hears from your dad that it's safe enough, okay? They have enough information to file the charge. Your dad gave us some information that you probably need some help, with some, like, depression or something. So I was going to ask, and you meet the criteria for pretrial release, does it hold him up? Is it more practical for him to go straight pretrial release, or should I ask for him also to be screened for mental health pretrial release, because he might be able to get some counseling and/or treatment up front?
You can have him screened.
Does it hold him up from getting out? Does it take them like 4 days to screen him and only takes 24 hours for him to get out on PTR?
Not lately, they've been quick with giving us a response,
Okay.
most likely some.
All right, let me ask, Mr. Ibarra, we have the straight pretrial release where you have to like report to them and, subject yourself to random drug screens and stuff, but you can get out without post and bond. And we have another alternative program, which I could put down as an alternative if you qualify, which is called mental health pretrial release. And that is a program whereby you could possibly get some evaluation and treatment started that is provided for, like some free treatment. Are you interested in being screened for that?
I'm more interested in the first option.
Okay. Well, I'm tempted to just put it down for what you want, because if they screen you and you don't want it, then it's just a waste of your time and their time. It is just an option for possible free treatment. But I'll leave it off the paperwork if you're not ready for that.
Yeah, I'm not ready for it yet.
Okay. All right, then. I just already told you it's going to be no contact, separate residence for now, and a police escort to get some things out. And pretrial release is okay. And the only other thing I'd tell you is, sir, life is getting pretty rough out there, and I don't think there's any shame in getting mental health treatment. I always run to a counselor if I get pretty much a hangnail or something. I mean, at the least reason I go get counseling, because I figure they're objective, and I don't like to live in a mediocre state. I'd rather be, at the top of my game and joyful, and sometimes that involves getting in touch with stuff that might be subconscious. So, I mean, I'm just telling you, I think it's healthy, and there's no shame in it, and I wish you good luck.
Your Honor, are you going to order weapons and firearms?
Okay, thank you. She's reminded me of a standard requirement that if you have any guns, knives, or weapons, you put them in the custody of the arresting agency within 24 hours of your release. Good luck. Okay. You want to handle those? Let's just see here for a second. I'm used to the public defender skipping them instead of bringing them back, but I think on the domestic, well, we don't have a public defender form, but on the domestics, well, he's,
Your Honor, I'll waive the appearance for today, and just ask that you set a bond in his case.
the only thing I worry about on the domestics is he's PTR eligible, I think. although there's a hold,
I'm
right?
gonna,
Check on
reprint
that.
you an, updated.
Okay.
We can come back to this one at the end like we did yesterday, Your Honor,
Yeah,
so that,
you want to do the people who can't show up at the end?
yes.
All right. Then this is Ms. Myers.
Myers, medical.
Okay, if it's okay with you all in regard to the paper flow, can we go through the ones where people are here? All right? Okay. All right, is this Ms. Riffin?
Correct.
Thank you, ma'am. This is case number 2021 335580. And Ms. Riffin, let me check with the public defender's application. You qualify for the public defender's representation. We're going to appoint their office to represent you, and the paperwork will let you know how to get in touch with them. It looks like they have enough information to file the charge, and we don't have a witness, so that means that we're going to have to order no contact for now until you get into court with the judge and the other witness tells the judge that it's okay and safe enough for you to have contact. So we'll also order separate residence for now. Although you live together, I don't determine who gets the dominant right of possession of the household, but would authorize you to get a police escort to get some things out of the residence so that you can comply with the no contact order pending that court hearing. And there's one child together generally. We would require that you comply with any orders by the Department of Children and Family Services in regard to custody exchanges or contact. So in this case, it was indicated on the paperwork that the kids might have seen the incident, and therefore it is likely that there will be an open case with Department of Children and Family Services, and you would follow their directives in regard to custody, exchanges, visitation. State's going to ask for a standard requirement that if you have any guns, knives, or weapons, you get those to the arresting agency within 24 hours of your release. And otherwise, she, according to the paperwork, meets the pretrial release qualifications. Anything to be said about that?
Your Honor, I would just ask that she's placed on pretrial release. She has, it looks like, very little criminal history and 0 failures to appear.
State has no objection, Your Honor.
Okay. So, ma'am, that means you can get out without posting bond, but you'll be reporting to the pretrial release office, since that's, how we make sure people know about their court dates and get back to court. All right, good luck to you. Is this Mr. Roman?
Yes, ma'am.
Thank you, sir. This is case number 2021 335780. Looks like you do qualify for the public defender's representation. We don't have a witness here. So we are going to order no contact for now until a judge hears from both parties and determines that it's safe and agreeable to have contact. Now, I think that you all were living together, and I don't need to determine who gets the household and the premises that you're living in, but if you need police escort in order to get some things out of the residence in order to comply with the no contact order for now, you can have a police escort to get some things out of the residence. You have a child in common. We're going to require that you follow any Department of Children and Family Services requirements in regard to custody and/or custody exchanges. Or if no Department of Children and Family order, then you would have custody exchanges through a third party such as a relative or family friend, mutually trusted family friend. State's going to require that you have no guns, knives, or weapons. If you have any, that you put those in the custody of law enforcement.
Your Honor, to be clear, you ordered separate residences?
Separate residences, if I was not clear, would be ordered. Thank you.
May I add something also?
So you might want to talk to your lawyer first because you're, could accidentally admit something.
I have no.
Your Honor, just for the record, they both currently work at IHOP. I did advise that he should not be working the same shift as the alleged victim, but I would just ask that as long as he stays 500 feet from her, that he's allowed to still work at IHOP. So if she's there, he can't go.
And the other alternative is to call your public defender as soon as possible to get in front of the judge because that sounds like a complication.
Yeah, correct, Your
You
Honor.
can't, my recollection of waitressing was that you don't really have control over your schedule. It's whoever the manager is. And so, and you don't, want to get into that situation where you're trying to work anyway, and so you tell yourself it's okay, even though she's there. Because you come back here on a violation of a release condition, you'll be at no bond. And there's no guarantee you're going to get the same kind of judge like me. I mean, it's really common that you can just get no bonded on that and you're just stuck.
Thank you, Your Honor.
So I'm okay with, the only thing he's got on his record is a DUI, but apparently he meets the PTR requirements. If he's only been here for about 4 months, but he's gainfully employed, he's been with the same company for a while. Are we all okay with the pretrial release? Now,
Yes, Your
the
Honor.
fact that you both work at IHOP, that's a little bit of a problem for you. So you're going to have to really talk to your boss about, I really need a different shift and get into court as soon as possible to see if, the judge can hear from both of you about whether it's safe or not to at least work at the same place. And good luck with the other guy in the quote relationship, unquote, whatever that means. That's obviously an aggravating situation. Okay, is this Mr. Thomas?
Yes, ma'am.
Okay, thank you, sir. We have case number 2002-1MM333480. And we can appoint the public defender to represent you at this time, and you'll have their address and phone number to be able to contact their offices. So notwithstanding some criminal history, pretrial release said that you might, I'm not sure if you were eligible or not, but if you were eligible, they would need more verification of your community ties, notwithstanding the fact that the alleged victim was allegedly your mom. So presumably, if they got in contact with her, they'd know. She's not here. So we are going to have to order no contact with her until you're both in court and she tells the judge it's okay and safe. And you'd have to have a separate residence for now until a judge hears from your mom. And you can have a police escort to get some things out of the house, presumably to move in with another family member for now because you're young. Pub defender, separate residence, no contact. They have enough information to file the charge. Now, as far as his release, did you ever get the community ties established? Does he or does he not meet the criteria? He's got some bit of prior criminal history, so I'm not sure if he meets the criteria or not.
He could qualify, Your Honor. I just had a question. He did put as an alternative address to go live with his brother who lives in Pennsylvania.
Pennsylvania.
So that she was, I didn't know what she was exactly asking. I thought she needed like somebody solid. I actually have a house to live at, my friend's house, Austin Littis. I just talked to him over the phone. At the time, I didn't have a chance to contact him. He wasn't answering the phone. He was asleep at the time of my pretrial conversation. So I
So-
gave a solid one for someone who was confirmed.
So what we
Brother
could,
confirmed, like without question, I had a place to live.
all right, so we could put either a bond that is commensurate with the misdemeanor charge and also an alternative of pretrial release if you're eligible, so that we could cover it. So either you're eligible, or if you're not, you still have a bond.
You can just do a straight PTR, Your Honor.
We can do straight PTR? Okay. And so there was also, there's also a program called mental health pretrial release, which is like pretrial release, but they also have some free treatment if you're ready for that. And if you want to get started, sometimes that helps you get more information to help dispose of the case that, you're getting some treatment.
Your Honor, generally when the defendant is already seeing a mental health doctor, which it appears that he is, since he already has bipolar medication, they won't qualify for mental health PTR.
Oh, because he's already got the
He's already
treatment?
being seen by a mental health professional, and we try to save those spots for,
People who don't have it.
yes, Your Honor.
All right. Okay. So with no objection, we're going straight pretrial release and no contact, separate residence for now, but police escort if you need it. If you have any guns, knives, or weapons, put those in the care of the arresting agent office, law enforcement agency within 24 hours of your release. That's a standard requirement. And you'll get your public defender's address and phone number because you want to be represented by a lawyer who knows what your case concerns are. All right, good luck. You're welcome. Are we moving on to traffic? Yes. All right, so we'll put the people who were in the hospital over here for a moment and deal with them at the end. Okay. Is this Michael Cherry? Yes. Sir, thank you very much. Okay, so the allegation is driving while license suspended in case number 21CT478AE in Division 83, and you would qualify for the public defender, sir. And you might have a complicating situation in regard to being out on bond for driving while license suspended in case number 2020 CT 2215AO. So there's a detainer for that. The officer's report indicates that you have some suspensions for like a DUI refusal.
Your Honor, there is an offer to resolve all three of his cases.
Okay. And just be aware, sir, that these convictions add up against you could trigger a 5-year revocation. So I used to maintain a docket where I would actually educate people and encourage them to get it situated. If you gave up on a DUI, is what really happens, is you give up on the DUI and then you keep coming to court and getting more driving license suspended. Next thing that happens, you got the 5-year revocation, and then, you see these guys riding their bicycle around town, that's because they gave up. And if you try to work and be like an adult while you're on a bicycle in this town, That's almost impossible. So if you're at the point where you're ready to dig deep and get on your bicycle and work 2 jobs to pay for the DUI, then you want to try to get out and see if you got a judge who'll work with you. I don't know what they're doing. I did. I mean, I worked with a guy one time for 11 months to get him to get his DUI cleared up, because I get tired of seeing these poor guys riding their bike when they're 58 years old and they haven't been able to have a real job
Yes.
for what should have been their adulthood. So, you know,
Your
you want to crap up your license and never get it back, then plead out.
No, you're,
If you want to dig in and figure out if you can do adulting, then, you know, let your lawyer try to help you.
Your Honor, we're just going to ask that you set a bond in this case
Well, he has,
so he can have a chance to get his driver's license.
you're, what's this, false ID? Told him wrong. Yeah. Not sure I'm looking at the same driving record that I used to have, but, you know, just what the police officer put. So I don't know how bad it really is. And you're how old? 33. All right. Okay. All right, I see where we're going with. So on the new driving while license suspended, this is kind of low, given all the things that you've been running away from. And my risk is that I let you out, you get back in a car and you cause somebody some injury, and then it's my fault for letting you out, and I get to be on the TV news because I let you out. So I want you to understand, I'm taking a risk too, because I see you running away from this stuff. But I will go along with the bond schedule amount on the paperwork of $500 for the new case, 21 CT 478 AE. And also, the judge from the prior case wrote $500 bond on the old one, 2020 CT 221580. So I'm taking a risk, but I can also see what happens. It's up to you whether you are ready.
Your Honor, so are you revoking and setting it at 500?
Isn't that what, wait a minute, was that, no, that was the previous bond, right? I'm sorry. He was out on a previous bond.
Yes.
Sorry. Let's double it, revoke it and double it to 1,000. And I probably should do more.
Yes, Your Honor, and in regards to the 21MM96AE, the false ID?
Yeah. Oh, is there another one?
Yes, Your Honor.
I just did 96AE. Is there another one in addition to that?
No, Your Honor, I believe you did the driving while license suspended, which was $500.
Oh, wait. So,
He has a
96AE is the false ID.
Yes.
And, okay, that's at 1,000 also. Okay, so the old driving while license suspended, 2020 CT 2215, we'll just revoke and double that to 1,000. So you got 1,000 on the old Dwellis, 1,000 on the false ID, going to Division 62, and 500 on the new driving while license suspended. So the false ID, and the driving while license suspended, it doesn't make any sense that they're going to separate courtrooms right now, but I never was able to convince the clerk's office to put them together. We used to put them all together here, but somehow we can't do that anymore. So you're going to have to keep up with your multiple court dates. Best thing you can do is talk with your lawyer to help you keep them straight. Good luck. All right.
Your Honor.
Good morning, sir. Is this Mr. Garcia?
Yes, ma'am.
All right, thank you. let's see what we've got here. We have case number 21 CT 3597AO. It's going to Division 81. Looks like they've got probable cause on that. We can appoint the public defender to represent you. And normally, they're not going to want to resolve a DUI today. Am I correct?
Yes, Your Honor.
Okay. Any objection to the standard bond that's on the paperwork?
No, ma'am.
No, Your Honor.
All right.
State would also ask for no drugs or alcohol in random UA.
Well, it says he meets pretrial release authorization, notwithstanding a prior drug history.
Yes, Your Honor, we would just ask for pretrial release since he qualifies.
So, well, let me put it to you this way. This is what I'm tempted to do. Pretrial release, if authorized, with no drugs or alcohol and random screening for drugs
And alcohol, Your Honor.
or alcohol. Or straight bond if you want to not be screened, because we don't have a way to screen you if you're on straight bond. But,
There is, Your Honor.
Your Honor, there is.
ma'am, there is? Oh, okay. So the state's requesting, I'll go ahead and add it on the bond too, because of the prior history. Make sure you come back to court, and if you want for your lawyer to have a chance, then you need to talk to them before you come back to court.
Yes, ma'am.
So which one are you going to do, Your Honor? Are you going to put him straight bond or PTR?
Is there any logic in giving him an alternative?
It's whatever you decide. I don't think he gets an alternative.
The only reason I do that is because I used to see it get hung up sometimes.
Your Honor, state would ask for PTR, so he's otherwise monitored.
Okay, he seems to be okay with that. Let's just go PTR with the monitoring for the drugs and alcohol.
That's fine.
All right, no problem. Everybody's in agreement.
Thank you, Your Honor.
You're welcome. That gives me the willies. A guy did that one time, and then I let him out on just a regular DV, and he murdered his wife. So ever since then, it just gives me the willies when somebody thanks me afterwards. Yes. And that was probably 30 years ago. All right, is this Mr. Kelly?
Hospital, Your Honor.
Oh, okay, so we're going to add him to the group that we're going to recall. Thank you. Is this Mr. Mohammed? Thank you. We'll add him to the group that we'll deal with after we get through the line of folks. Is this Mr. Sicardo Amalber?
Yes, Your Honor.
Okay, I was attempting to pronounce your name. Okay, thank you. And this is case number 21CT3600AO, going to Division 84. I'm not seeing a public defender form. Did you fill one out, or are you planning to get a private attorney?
I had to defend myself.
To represent yourself? That's about the best way I know of getting yourself convicted, whether or not you're innocent.
Well, nobody really told me anything, Your Honor, so I just.
Okay, well, that's understandable. Well,
Pursuant to the admin order, we just ask that you appoint the PD.
So we do tend to appoint them just in case you change your mind, because if we don't appoint them and you change your mind, then nobody started getting the paperwork from the state. And if you change your mind, then somebody started to get the paperwork from the state, because you're not going to know how to do that yourself. And you could just get it from them or give it to whatever private attorney you get, okay? Also, it looks like you had a prior DUI, and so you probably need some help. Let me see, I didn't. Read this far down in the stack. Let's see, refusal. Okay. It looks like they have enough information to at least file the charge. So we'll temporarily appoint a public defender, and you figure out what you want to do with that, but every judge is going to be concerned that you're represented. Was there another charge in regard to the white powdery substance, or did that not get,
No, he was just charged with the DUI.
just the DUI? Okay, all right. And they set it at 1,000 because of the crash
Crash and history, Your Honor.
in history, because of the prior DUI.
It's standard to double if he has another one, or if it's over .15 blow, or personal injury or damage.
Or the printer's running, was it a refusal? Is that the reason?
There was a refusal, Your Honor, but that's not the reason that the bond is doubled. There was personal injury or property damage,
Right.
or over a .15. In this case, it's
Oh, got
property
it,
damage.
got it. Okay. So we'll leave it at $1,000, sir. Appoint the public defender, hoping that you take advantage of that so that you can have a fair situation. We'll give you their address and phone number. We're going to give you court dates that you need to come back to. And you can't get any law violations while you're out on bond.
Your Honor, no drugs or alcohol without a valid prescription RUA.
Is that just something you're doing on every DUI now?
When there is an allegation of drinking, Your Honor.
For every case? And that's what the judges are doing now, just telling everybody?
Yes, Your Honor.
I'll go along with what they're doing. I'm a substitute judge, so we'll tell you not to have drugs or alcohol while you're out on bond. Good luck. You're welcome. Okay, is this Mr. Upton? Okay, thank you, sir. We have case number 2021 CT 3108AO. Which is going to Division 81, and it's on a failure to appear, sir. We'll appoint the public defender if they're not already appointed. But that is a driving while license suspended, and is currently at $2,000 bond, which was the amount set by the judge before whom you were supposed to appear.
Yes, Your Honor, there is an offer on that case of a withhold and credit time served. On his other case, however, there is no offer, as it is an Osceola case.
Okay, and the Osceola case is an out-of-county warrant for $1,500 on some unspecified traffic offense.
It's a dwellish, Your Honor.
All right. So, the only thing I would say, did I get them all, or is there more than one?
There's only those two.
Okay, just duplicate paperwork. Sir, so you're 19, and if you start pleading out to them and just accepting fines, you dig yourself into a hole real quickly where you can, never drive again. You see these old guys riding around on bicycles? That's because they can't. So, up to you. If you want to plead out, it's easy for me, I get the case over with. But if you want to start digging yourself out of the hole, then plead not guilty and start, get a second or third job while you're riding your bicycle, which you can do at your age because you've got enough energy. And then dig yourself out of the hole, in which case you plead not guilty. But, these things add up. And not only that, they start adding up in terms of a 5-year revocation if you get too many of them.
I believe he currently has 3 open, Your Honor.
3 open? Well, you're just on the edge of the hole for a 5-year revocation. Hey, good, how are you doing? You should be retired by now. One more year? It's the best job you'll ever have. Okay. Okay. Division 84, and it's,
Your Honor, he would like to accept the state's offer on the failure to appear case, of a withhold credit time served.
okay. So I don't know what Judge Dewitt would do. Does he know bond, or does he put? Okay.
We appointed.
We'll let, okay, thank you. Good luck. Okay. All right, Mr. Upton, it's not what I would recommend, but if that's what you want to do, I'll accept your plea. You are walking into a big, big, deep hole. Understood? I mean, I've told you, if you start pleading out to these, you're going to get a 5-year revocation. If you don't plead out, the judges might work with you, but you will have, to make up your mind to work a couple jobs and dig out of the hole and do nothing other than focus on that, or you're just not going to get a license for a very long time. And then when you drive, they put you in felony court. And you could be a convicted felon and not be able to vote.
Your Honor, he understands and he would like to accept the state's offer.
All right. I'm perfecting the record in case he wants to come and open it up later. In addition to the fact that he really needs to understand the consequence of this. Mr. Upton, if you want to get the case over with, would you raise your right hand to be sworn in? Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay. Thank you. You can put your hand down. And I need for you to speak up just a little bit through that mask. Thank you. So in regard to 2002-1 CT 3108AO, it's a $2,000 bond, and I guess your word you can't get out, but you'd be giving up all the rights listed on the plea form if you enter a plea of no contest. Do you understand that?
Yes, Your Honor.
Okay, and you need to really speak into that microphone, because I'm making a record of you understanding what's going on, okay? It gets recorded. So I've asked you all the questions about, that you're walking into a 5-year revocation. And also, you're giving up these rights to have a trial, to have a defense, to see if the public defender can help you with any technical defects in their case. And you're giving up the right to require the state to prove beyond a reasonable doubt that you were driving when you should have known your license was suspended. They would have to prove it to a jury of 6 people who would have to be unanimous that the state proved it. You understand that?
Yes, Your Honor.
Okay. And probably more importantly, you're giving up the right to see if you could try to work on the suspensions so that, sometimes you can get a break and not have to plead out on all of them as driving with license suspended. Sometimes, if you get your license back, you could get either a no valid or you even get it dropped. In some cases, if the state thinks that you really worked on it, you're giving up the right to work on it and get some accommodations where you don't have to face a 5-year revocation. Do you understand that?
Yes, Your Honor.
And you still want to get the case over with, even though it's going to be a strike against you for the purpose of a 5-year revocation, a 3-strike rule?
Yes, Your Honor.
Any questions?
No.
You're not under the influence of anything? You're only 19. Did you graduate?
Yes, Your Honor.
All right, so you can read and you can understand this form. Okay, all right. I'll accept your plea of no contest as being freely and voluntarily entered. There is a factual basis. The withhold of adjudication, it may or may not help you. I'm not sure what, happens these days. We'll give you credit for however many days you got time served. What is that, about 2? 2 days? All right, release you as to that charge. The court costs, does the public defender want me to put the PD fee on there? Not?
No, Your Honor.
Okay, so we're going to pretend that you didn't have a public defender and not charge you the fee. The court costs, probably around $300. I don't even know what they're charging at the moment. I'll give you a year to try to work on that. But, so that you can work on your other suspensions first if you decide to try to work on it with the other cases. And, then, you also have that other case for Osceola, but they'll give you a lovely ride over there, unless you bond out on that.
Yes, Your Honor.
So you're saying the bond on 21 CT 942 and appointing the PD?
Yeah. Since he's rid of this one. Good luck. Is this Mr. Vasquez? Okay, good. All right, no, but, oh, okay. Do we have an arraignment stack? Is that it? Thanks. Garcia's medical? Then he's got 13 days in. Does that, on a no motor vehicle registration case? And we don't know if he's ever going to come back to court. See, a lot of people have medical problems here.
Your Honor, there's a jabber docket that can help take care of that.
There's a what?
A jabber docket
Jabber?
for in custody defendants to accept pleas.
I believe, due to COVID, Your Honor, they have to.
Yeah, is everybody getting sick in here? There's a lot of people sick. Is it COVID? Holy cow.
I believe they keep them separated for a certain period of time before they can come to court, Your Honor.
Yeah. All right. So I think the state told me about some docket where they can plead out even though they're not here.
Yeah, I'm assuming Ms. George is probably going to waive it. It's going to be set for a pretrial. I know you stated that he had a certain amount of days in on a no motor vehicle.
Okay, so that, we did a bunch of those yesterday. We just waive them and you guys help them out somehow instead of keeping them forever on a no valid registration.
They later get put on that jabber docket to plead.
Holy cow.
Yes, Your Honor. So we'll waive.
You'd think we could waive his court costs if he got COVID on a no motor vehicle registration case.
Your Honor, if they're medical, it's not necessarily that they have COVID. They get quarantined for a certain amount of time when
It
they
just
get.
seems like there's more than ever. I mean, I'm used to the jail docket, and I've never seen so many people unable to come to court. It's frankly shocking.
So I'll waive the appearance and enter a plea of not guilty, Your Honor.
All right.
The pretrial date will be Division 82, June 14th at 10:30 in courtroom 10B.
Okay, same thing?
Yep, are we appointed? It is not showing up. Okay. I'll waive and enter a plea of not guilty.
Division 61, pretrial date will be June 28th at 1:30 in courtroom 6B.
And just to be clear, for Garcia Gonzalez, I was on both his cases, 21 CT 3323 and 3322.
Oh, you're reading the case number in for the court reporter?
Yes, because we
Okay.
did Mr. Garcia Gonzalez for the 3322. I just wanted to make sure that that was also 3323.
All right, I guess I can barcode these in. So the next one is Robert Arce, A-R-C-E. He is here, and this is case number 2021MO 46280. He's been in for 30 days on a open container charge.
Yes, Your Honor. We're gonna enter a plea of not guilty.
Okay, Mr. Arce, if you got something else going on where you have to enter a plea not guilty, I think maybe your lawyer knows what she's talking about.
Yes, I spoke with her about it,
Don't talk.
and I would like to enter the plea of not guilty.
Okay, no problem. We'll give you a court date on that.
Pretrial date will be in Division 85, June 14th at 9 o'clock in courtroom 4A.
Okay? Right? Okay, that's case number 2021MM2707AO.
I'll waive and enter plea of not guilty, Your Honor.
It's Division 63.
Pretrial date will be June 10th at 1 o'clock in courtroom 12C.
Okay, thank you. Is this Astor Levy?
Yes.
Okay, thank you. Case number 2021MM2718AO. And you've been in for 27 days on providing false ID to law enforcement. It's Division 63. Public defender is representing you.
Um, Your Honor, the state. Your Honor, the state is offering adjudication of guilt, credit time served, in order to resolve the providing false identification to law enforcement. And he would like to accept the state's offer here today. However, he said he came in with a drug paraphernalia charge as well. Do you see that one?
I see it noted by the trial ASA that there was an offer of level 1 drug diversion for the paraphernalia and then an adjudication for this charge. However,
It's a paraphernalia charge. Would you?
I believe we only filed the false ID. I don't
Okay.
believe we filed the paraphernalia. I'll double check that real fast.
Yeah, because I don't want him to be held here.
1 second.
Is he being held on anything else?
I'm opening the information.
Okay.
Yes, we just filed on the false ID. We didn't file the paraphernalia.
Okay.
Okay, I didn't look it up because I'm not logged in. Okay. Sir, you can raise your right hand to be sworn in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, you can put your hand down. I need you to speak up just a little bit through the mask because I'm
Okay.
getting old. Right now, sir, it's a criminal charge, and they're asking for a conviction. I understand the desire to get out of jail, but criminal convictions are the kind of things you have to report on job applications and things like that for the future. Do you understand that?
Yes, Your Honor.
Okay. And also, they show up, hopefully you never get arrested again, but if you do, the judge sees that you've been convicted of something before, and, if you ever got a felony, then they add up as little points on your sentencing guidelines. So I need for you to understand the very significant consequence of having a criminal conviction on your record. Any questions about that?
No, Your Honor.
Okay. Now, you probably read a plea form yet, or did you sign it yet?
No, I haven't signed it yet.
Okay, now if you need time to read it, look at it, because you are entitled to know what's on that form before you sign it.
I'll be released today, right?
Yes, sir, I know that's the magic question, and you don't care about the rest of it, but I still want you to look at that form and make sure you understand it.
Okay.
Did you ever read it before?
Yeah, I have read one of these before.
You've read it before, okay. All right, then, in relation to the form, those are legal rights that you give up when you plead no contest. Thank you, sir. It means you won't have a trial, you won't have a defense. The state will not have to prove beyond a reasonable doubt that you committed this offense, and they won't have to prove it to a jury of 6 people who would all have to be unanimous that the state proved it. Do you understand all that?
Yes.
And nobody will hear any defenses or technical defects that your lawyer could possibly argue on your behalf. Do you understand that?
Yes.
Are you giving up these rights freely and voluntarily?
Yes.
You're not under the influence of anything right now?
No, just my medications.
Just your medications?
Yes.
Okay. And are you clear in your thought process and understanding while you're on your medication?
Yes, I am.
Okay. It does appear that you are alert and intelligent, that you are understanding the rights that you're giving up, and that you're doing so in a free and voluntary manner. Also, you've been represented well, so I think that we can accept your plea as being freely and voluntarily entered, sir. As far as the factual basis, I'm not being presented with that, but I guess I can go on the fact that it was a probable cause determination.
Would you like a factual basis, Your Honor?
Well, as long as can you make it quick?
We can stipulate, can we
Or stipulate? Can you-
stipulate to
You
a
want to
factual
stipulate? We'll
basis?
accept the stipulation. I'm used to having it in front of me, but I'm happy to accept a stipulation. So we'll accept a stipulation, find adjudicate you guilty on the charge of providing false ID to the law enforcement, giving you credit for 27 days time served, release you as of this charge. So, sir, there's going to be court costs that I think are in the range of about $300, plus probably a public defender application fee of, I think, about $50, but I'm not sure. And I think what we do is we just give you a year to work on it. You don't have to pay it to get out, but you want to work on it, I'll give you a full year. And because in Florida, we revoke your license when you don't pay your court fines.
Okay.
And you can make partial payments, and I think you can even make them online over the internet to the clerk's office. So keep track of that so you don't become one of those guys who comes in here all the time on a driving license suspended because you forgot your fine.
Okay.
Okay?
Your Honor, it's been brought to my attention by Ms. George that he is currently being held at the jail for the paraphernalia as well as this charge. So I just ask that you put on the record that he's ROR'd as to the paraphernalia. It does look like he's still being held on it.
Oh. Okay, thank you for checking that out.
Yeah, they'll take care of it once they see the plea for this.
I just wanted to make sure he wasn't sitting here since we only charged one
But the
charge.
clerk says no action, so they'll close it out.
So they'll be okay? We don't need to enter an ROR order on that?
No, they'll see that they took no action on it, so they'll close it out. I mean, if you want to put it on the,
Yeah, let's do the ROR on the paraphernalia, but the clerk needs a case number, right? Is it the same case number?
Yes, Your Honor.
ROR as to the paraphernalia charge because it was not filed. If we put that down there, anybody could understand it.
We just don't want him sitting
Yeah,
since he already pled.
Right, I think it's better to be excessive in regard to what we order so that we know he's got it handled. All right, good luck to you.
Thank you, Your Honor.
Okay. Is this Mr. Martinez? Okay, thank you, sir. This is case number 2021MM1127AO. And Mr. Martinez has been in on alleged battery and criminal mischief charge for 6 days, Division 62. And we don't have an attorney assigned yet, although you're always eligible to ask for public defender because you're entitled to be represented whether or not you can afford a private attorney.
Your Honor,
That'd be nice. I'd like a public defender.
Okay,
In your honor, I will enter a plea of not guilty.
all right. Did you all have a chance to talk?
Yes, your honor.
Okay.
With the ASA.
So does he know what his release conditions are? And he's been in there for 6 days. He might need to review that.
Your Honor, I already have the PD appointed on this case.
Yeah.
You'd be what?
I think the PD was already appointed on this case.
You're only here for arraignment on these two.
Am I the only one who can't hear?
I believe the PD was already appointed on this.
We're, even though it's not showing, we are appointed.
Oh, okay.
And your honor, we'll enter the plea of not guilty. Since there are batteries and criminal mischiefs, there's no offer to resolve today.
All right, well, Mr. Martinez, for some reason, it takes the state until pretrials to figure out what they're going to do. Not this one, she's really good, but for some reason, I don't know why. So you might want to work on getting somebody to get your bond posted, because if you're just waiting for a plea offer, it could be a good while. All right?
The trial date will be in Division 62, June 14th at 9 o'clock in courtroom 9B.
I did have a prosecutor once who figured it out by arraignment, and he could make plea offers on victim cases, and that young man is making a ton of money now, because he has figured things out. he's getting wealthy, and I was so impressed because he was always well, I saw you resolve one yesterday.
It's often if the victims can't be present and they want to be present, then we can't.
Right, yeah, but the cool thing is that some lawyers figure out how to get a hold of victims and some don't, and it usually has a good predictive value in terms of how successful they're going to be on, their own eventually, is what I'm saying. I've been watching it for a long time. But some, they can't figure it out until pretrial. They just can't figure it out. All right. Have we got anybody else for the arraignments? Okay, that's case number 2002-1254580. James Smith.
Oh, I'll waive an interplea of not guilty, Your Honor.
Pretrial date will be in Division 81, July 2nd at 9 o'clock in courtroom 4E.
Okay, we got, okay, 2021MM249680.
I will waive an interplea of not guilty, Your Honor.
Okay,
Trial date will be Division 83, July 6th at 10:30 in courtroom 6C.
okay. And what else? Are these 33-day motions? Okay, thank you. Oh, all the no contact orders, okay. All right. So, I appreciate what you did with the 33-day orders yesterday.
I can go through them the same way, Your Honor. That's easier for
Okay,
you.
thank you.
Thomas Jordan, 21 CF 4311, notice of non-filing.
Wait, I barcoded the wrong file. I've got, where's Jordan? I've got a Diaz Gonzalez.
That's the add-on, Your Honor.
Oh, okay, so Thomas Jordan, let me go ahead and barcode that, is 21 CF 431180. And did you say that was a non-file?
Yes, Your Honor.
Okay, so we'll grant the motion for release.
Salim Jarman,
Okay,
21 MM 2542, notice of non-filing.
okay, the motion for release is granted.
Bridget Taylor, 21 CF 4385, notice of non-filing.
Okay, thank you, the motion for release is granted.
And then 21 CF 4187, Jose Diaz Gonzalez. This case was called back on May 9th for an ROR motion, and state filed an INN 27, so a notice of non-filing. So I don't know why it's back on the docket, but we filed a notice of non-filing back on the 9th of May.
Is he still in there?
I believe so, Your Honor.
He still is. He's still in custody.
You still in? Okay, so it's ROR on this one. Hopefully this didn't keep him in after we supposedly ROR'd him already.
It did.
It did?
It did.
And that's why I am happy to do things in an exaggerated fashion because it's hard to keep track of everything, evidently. Okay. Not sure.
Taylor May on behalf of the Office of the State Attorney.
Letitia George on behalf of the Office of the Public Defender.
Thank you. Thank you very much. Okay, thank you all. Okay, must be some move-ups, right? Okay, all right.
No.
No? Is this Mr. Flagg or is this Mr. Oreo?
Mr. Flagg, good morning.
Okay, maybe I've got,
Afternoon.
okay, I think I did not bring in some stuff. Okay. Mr. Flagg, this is case number 2002-1MM3354, city ordinance for disorderly conduct and possession of drug paraphernalia. It looks like they have enough information to file the drug paraphernalia charge going to Division 61. And we can appoint the public defender to represent you if you want. Is this one you all are trying to resolve?
Yes, Your Honor. In regards to the 21MM 3354, the state is going to announce a no information as long as he pleads to the other case number for the city ordinance, the disorderly conduct, the offers of withhold and contempt served.
And he does want to accept the state's offer here today, Your Honor. He went over his rights, and he understood those rights he would be given up in order to resolve the case today.
All right, thank you. That's the 21 MO 5844. Okay, sir, would you raise your right hand to be sworn in? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you, sir. You can put your hand down. Did you understand that you would be giving up the rights on your plea form in regard to the disorderly conduct charge?
Yes, ma'am.
You won't have a trial, you won't have a defense, nobody will have to prove it. Any questions about your rights?
Oh, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
Okay. And this was a conviction at time, sir?
Oh, withhold, Your Honor.
Withhold? Okay. All right, I will find that Mr. Flagg is alert, intelligent, entering a plea of free and voluntary manner. There's a factual basis. We'll accept the plea of no contest. Withhold adjudication on the charge of disorderly conduct. Thank you. Sentence you to the, probably 2 days' time served, whatever it is. And sir, there's court costs. In this context, we generally give you a year to pay. In case you're trying to work on your court costs, you can make partial payments. So the state filing an all pros on the other one?
Your Honor, the state announces a no information in open court, and I just followed that up with the clerk's office
All right, thank you.
as to 21MM 3354.
Thank you very much. Is Mr. Smith? Thank you. All right. All right, sir, the new case is a petty theft, 2021 MM 3349, Division 80. And we can appoint the public defender if you need it. Looks like they have enough information to file the charge. You also have, you probably know, an first appearance hold for Osceola on a petty theft with 2 priors, case number 2002-1 CF 1285, although previously you were released on that. My guess is you don't want to resolve it,
No, Your Honor, due to it being enhanceable.
right? Okay. Sir, we'll appoint the public defender, but what happens on these petty thefts is eventually they can start up-filing them because of your priors. They can be upgraded. So the state doesn't want to resolve it right now, and I'm okay with that. Leave the bond at $250 on the new petty theft.
They would also ask for a no return to the 7-Eleven, Your Honor.
Don't return to that 7-Eleven.
In regards to his out on bond, state would ask that you revoke, and if you're inclined to set a new or higher bond due to being the same exact offense that he's out on bond for.
Yeah, he was released on unrecognizance. So I'm trying to figure out if that was, it's not evidently a 33-day motion. So maybe it was just a merciful release or maybe a factual basis or something, I don't know.
Yes, Your Honor.
But in Osceola, they usually, it's not unusual, they used to no bond people on these, but I'll just do, in an abundance of caution, set bond at 1,000 on that because of the prior criminal history and the new charge being the same kind.
So to be clear, you're revoking and setting at 1,000?
Okay.
Okay.
Thank you. Burnett Woods, thank you. Okay, this is we have case number 21MO 585AO in Division 63, which is an alcoholic beverage container case. Appears they have probable cause for that one.
Your Honor, I am authorized on the city's behalf to offer a withhold and credit time served on the open container case.
Okay. And she also has out-of-county warrants out of Lake County for 2 counts in regard to trespassing and resisting that are $2,000 apiece, which she probably might be transported on. Also, let's see, looks like duplicate paperwork here. Right. So if you resolve these, you'll probably be transported to Lake County. Right. Is that what you want to do? Okay. All right, so when we ask you some questions, go ahead and answer out loud if you could, because we have to get everything recorded. Thanks. I think they're going to let you sign it first. All right, Ms. Woods, would you raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Thank you, Ms. Woods. You can put your hand down. Okay, ma'am, probably the withhold and time served is good, but do you understand all the rights on your plea form? Or that's, well, you handed it to me, ma'am. Had you read the plea form before? Have you looked at it before?
No, this is my first time here in this court.
Really? Okay. Well, perhaps we'll let you look at one for a minute. Those are your legal rights to have a trial and a defense and to have the public defender check through your case for defenses.
Okay.
Okay, you're seeing it now?
Mm-hmm.
Okay, so the state won't have to prove beyond a reasonable doubt that you committed this offense, and you won't have a jury of 6 people who would have to be unanimous in believing that the state or the city proved the charge. Do you understand that you're giving up your right to have a trial and a defense?
I have a trial.
When you plead no contest, you're saying,
Well,
Judge,
I was set up.
Wait.
Someone gave me the can while I was out in the street.
when you
and I didn't know. I didn't even take
when
a
you
sip
plead
of it.
no contest, you're saying, Judge, I don't want the trial, I just want the time served and be done with it.
That's what I want. Time
Okay,
served.
I just want to make sure about that.
Okay.
Not trying to confuse you, I'm just trying to
Okay.
ask you the specific questions that I need. But if that's what you want, I'll go ahead and find that you are alert, intelligent, entering a plea of no contest in a free and voluntary manner, find a factual basis on the possession of open container, withhold adjudication, and sentence you to 2 days' time served. We do add court costs on those. We'll give you a year to pay in case you're trying to keep up with your court fines. You can make partial payments at the clerk's office.
Okay.
Good luck.
Your Honor, in regards to the 21 951, you're staying the bonds at 2,000 on each count?
Oh, yeah. Ma'am, you have 2 Lake County charges and I'm staying the bonds.
What do I do? I stay here and wait for them to transport me.
Yeah, but it won't be long.
It won't be.
No.
Now, if the charges at Lake County aren't real, they're false charges. Because I was here in Orange
But
County.
I can't do anything about the Lake County charges. You're going to have to go over there and deal with
So
it.
it'll be what, a couple days or?
Maybe. Not long. We don't have any reason to keep you, so they better pick you up right away.
All right.
Okay. So Raymond Galva bonded out. Thank you. Is this Anthony Barrett?
Yes, ma'am.
Okay, sir. We have case number 2000, wait a minute. 2002-1 CF 5769, Division 15, with the possession of cocaine and possession of drug paraphernalia in it. Okay, good. And it's we can appoint the public defender to represent you. This one's going to Division 15, Judge Wilson. Looks like they have enough information to file the charges of possession of cocaine, bottom out 1,000, possession of drug paraphernalia, bottom out 100. Sir, and is there a misdemeanor in here too? Misdemeanor number is 2021-MO-58380. It's going to Division 83. We'll appoint a public defender on that one too. And you probably want to just leave that and not try to plead it out yet. Talk to your public defender about resolving those. But they have enough information for just filing the charge, and the bond on that is the $250. If you do bond out, you'll have a court date in felony and also a court date in misdemeanor court, so be careful about that. All right?
Your Honor, you're going to make a condition, no drugs or alcohol without a valid prescription on the 5769 case?
Okay. Thank you. Okay, is this Mr. Baston?
Yes.
Okay, thank you. All right, sir, the case number is 2021 CF 577380. We can appoint a public defender to represent you. It's going to Division 17, Judge Alvaro. Possession of cocaine. Looks like they had enough information to at least file the charge, sir. And the bond amount on that is $2,000. Was there something that the release department needed in regard to identification, or did they get that cleared up?
They got that cleared up, Your Honor.
Okay, so your bond is $1,000. Make sure you come back to your court dates. We'll give you the address and the phone number of the public defender so that you can have them prepared for your court date.
Yes, could I ask you something, please?
You want to talk to your lawyer first before you
No, it's a
act?
simple question. I would like to see if you could release me on my own reconnaissance so I can get my vehicle out of impoundment while I can afford it. And I have a question with the amount, 0.15. I don't understand what that is.
Can I see that again? Yeah, well,
Your Honor, Your Honor, I don't
so you
believe,
just accidentally admitted something, and that's why you have to be really careful about saying anything. So I would recommend that you not say anything more.
he doesn't qualify for ROR due to the multiple VOPs and a prior failure to appear.
Okay. Sir, you know, sometimes your background and history complicates things. So I wish you good luck on that. All right, thanks. Is this Mr. Benson?
Yes, ma'am.
All right, sir. We have case number 2021, let's see, what's this? CF 5780, Division 17. Will appoint the public defender to represent you, sir. And on these trafficking and methamphetamine cases, sir, they come in with a high bond. It looks like they have enough information to file a charge. And my inclination is to leave it at the $50,000 bond on count one, the $10,000 bond on count two. I'm not really sure what the courts are doing in the downtown courts right now, but we'll just leave it for now, give you the public defender, and let you deal with that bond issue.
Yes, ma'am.
Good luck. Is this Mr. Travis Bridges?
Yes, ma'am.
Okay, thank you, sir. All right, in this case, 2021 CF 2722 in Division 15. 17, it's a violation of violation of condition of pretrial release on an attempted burglary of an occupied dwelling, signed by Judge Wilson.
Your Honor, there's actually 2 counts in that case. The attempted burglary of occupied dwelling, the F3, and a resisting without, M1.
I wonder, do I have all the paperwork? Because I've got the, I see. Okay, attempted burglary, occupied dwelling, and resisting an officer without violence.
Yes.
And Judge Wilson set the bond at $5,000 not to be modified. It was in regard to not reporting to the pretrial officer, so you'll need to go back to Judge Wilson on that. But you have the public defender appointed.
Your Honor, and all previous conditions are still set, correct?
All previously conditions are still set. Thank you. Okay, Johnny Dorr?
No, Terrence Foy, Your Honor.
Okay, is Dorr medical or something? Oh, okay, I'm just gonna put him aside then. All right, Mr. Foy, okay, we'll get, all right then, sir, all right, sir, we have case numbers 2021 CF 127AO, which is a failure to appear warrant on a petty theft with 2 priors, which Judge Laurent, I think, set at no bond because of the failure to appear. And then there's, and I'll leave it at that. That's in Division 11, and if you don't already have a public defender, we'll appoint one.
Yes.
Okay. And then you have 2021 MM 95AE in Division 61, possession of paraphernalia.
Yes.
That's going to Judge Johnson. And I think with multiple things going on, it might not be practical for you to try to resolve them, but they have enough information to file that one. And the bond on that one is $500.
Yes.
And then there's 2021 CF 5730 in Division 17. And that is a $500 bond on a grand theft less than $750. But that was an arrest warrant that was signed. And it was in relation to something which allegedly occurred on April 23rd at a Citco on North Orange Avenue in Winter Park. If you ever want to look that up, it's in the clerk's website.
Okay.
So you've got several bonds. We're appointing a public defender on everything.
Your Honor, can state request a no return on the last case, the grand theft?
The 2021 CF 5370.
Yes, Your Honor.
Okay, don't return there.
And to have no contact with the victims or witnesses?
No contact with victims or that's on the last one. You got that? Okay, so but you still have the no bond one on the felony, so you'll just have to,
Is there a court date on that? For the failure to appear one?
on the felony? Probably not, do we? Yeah, no, I'm sorry, we don't always have the court dates on the failure to appear warrants, but they come up fairly quickly.
Okay.
Good luck.
Thank you.
You're welcome. Okay, Mr. Dorr, okay, let's see. All right, sir, we have a new case, of 2021 CF 57556AO, a grand theft motor vehicle. Going to Division 20, Judge Wooten will appoint the public defender. And it appears that they have enough information to file that charge. And are those coming in at 2,500 now?
Yes, Your Honor.
All right, we'll leave it at whatever the standard bond amount is. Then you have,
Your Honor, can I also ask no contact with the victim or witness on that case?
all right, so ordered. We have a no-val license charge, which is 2021 CT 3595AO, going to Division 62. We'll go ahead and appoint the public defender on that. You don't want to resolve that one right now because it might be factually related with the felony. We'll just stay the bond at 500 on that. There was one more thing, sir, that you might have been out on bond on 2021 CF 575, wait a minute, no, 2021 CT 3595.
Your Honor, I
Sorry,
believe
wait a
it's
minute.
3069.
3069. Okay, which was a possession of methamphetamine. You got a lawyer named Brian Wynn on that?
That charge right there, ma'am, is done. It's done and over with. They just had to get finalized, I guess. Because they're on the part, I guess.
Maybe we could check that one out. The
Your Honor,
clerk's
it's-
paperwork says RO, he's been released on unrecovered. Hold on, because you might not know the bottom line on it, and I'm going to ask the lawyers to look anyway,
Yes,
okay?
ma'am.
Your Honor, that case, it's still open. There was a notice of non-filing posted on it in April 19th. So we got out ROR due to notice of non-filing.
Okay, so I'm not going to take any action on it. But let me make it a little more clear for you, Mr. Dorr. They had not filed it by the appropriate time, and so you were let out. And so that's actually good news, but it doesn't mean it can't come back and be filed later, as long as they don't violate speedy trial rules.
Your Honor, just for the record, that case was also a grand theft motor vehicle. Thank you, Your Honor.
All right, thank you. All right, and this is Mr. Hawk.
Yes, ma'am.
Thank you, sir. Okay. All right, this first case is 2021 CF 55780 in Division 15 with Judge Wilson. Will appoint a public defender to represent you. And that was in relation to a warrant in regard to 3 counts of aggravated assault with a firearm, which allegedly occurred on May 13th. And Judge Alvaro set it at no bond, may be modified, no contact with any victim or witness, no return to the scene of the alleged offense. And you have a couple of cases that you might have been out on bond for in regards to some drug charges, which we'll address in a little bit.
Your Honor, in regards to bond,
Yes.
the facts in the affidavit are particularly troubling. I do believe there's a discharge of the firearm. I believe 1 count of the aggravated assault with a firearm came when the defendant pulled the firearm and pointed it at the victim's face and head and threatened to kill them. The second and third counts of the aggravated assault with a firearm came from the witnesses hearing gunshots, and then the defendant walking to the vehicle and potentially demanding money, and then pointing the firearm at all the occupants in the vehicle. Arguably, potentially an armed robbery if money was exchanged. I don't believe it was, which is why that was not filed. However, the facts in the case are particularly troubling on all three accounts. So I'd ask for a bond that is appropriate with the facts in this case. I also believe that Mr. Hogg does have a pretty extensive history, a lot of which includes firearms and other violent charges. And for those reasons, state would also ask that you revoke his out on bonds.
Okay, counsel.
Your Honor, I would just ask that you take into account that when my client was walking from the direction of the alleged shots, no one saw him shooting a weapon, and that even though he is out on bond for his possession charges, they are nonviolent offenses. So if you are inclined to revoke, I would just ask that you revoke and set a higher bond. It looks like his last criminal conviction was in 2018 for criminal mischief. Okay.
All right, well, this is one of those situations. I understand what everybody's saying. I get worried also in regard to these sorts of charges, the new ones. I think some of us have been just a little too close to these circumstances. A little bit more happens, and then, you're facing an entirely different charge. So it gives the judge some level of anxiety to just let you out of jail instead of sending you downtown and letting them figure out, what will keep everybody safe. And so I'll set bond at $10,000 on each of those. No counts 1, 2, 3, no contact with any victims, no return to the scene. And based upon the prior criminal history, Mr. Hawk, it, looks like you've been, have a very significant work ethic with the number of cases you've had. But my reaction, given the gravity of everything, is to basically slow you down for now and revoke bond on the ones that you're out on bond for, the 2021 CF 191180, which is in Division 14. You already have a public defender. The 2021 CF 488980, which is in Division 20, and public defenders appointed. I think what really happens at this point is they start looking at it as a package and try to figure out what it's going to take to slow you down or keep the community safe. Good luck. Is this Mr. Hay?
Yes, ma'am.
Thank you, sir. We have case number 2021 CF 576780 is the first one with Division 19 Judge Roche. We can appoint the public defender on that, and that's a possession of methamphetamine, count 1, and drug paraphernalia, count 2. It appears they have enough information to at least file the charges, and the bond on the count 1 is the 1,000, bond on count 2 is 100. And you're out on bond in 2021 CF 2173. Or actually, you were released on your own recognizance on that for possession of cannabis under 20, possession of drug paraphernalia, and possession of methamphetamine.
Your Honor, I don't believe any information was filed in that case. I don't know if it's.
I'm having trouble hearing you.
I don't believe any information was filed.
So that would explain the ROR, perhaps?
It was a 33-day motion, correct? I'm not sure if that changed.
It has since been filed, Your Honor.
Okay.
It has or it has not?
It has one count of possession of meth, one count of possession of drug paraphernalia.
Thank you for letting me know about that. Well, how about we just, since it's been filed now, I suppose we could double it, but to what would it normally would be for 2,000 on the account of methamphetamine and 200 on the count of drug paraphernalia. Is there another out-of-county or something?
Yes, Your Honor, there is.
Okay, so that is an out-of-county for failure to appear on burglary of an unoccupied dwelling, and that is, it's 5,000, is out of Volusia. So, oh, okay. There's just one, right? I think I might have a little bit of duplicate paperwork. So you got 3 cases, sir, and you might want to just be patient for a little while. Hopefully your body is able to recover from any addictive substances you have for a while. Maybe you'd be better off in the long run. If you can get any drug treatment in the jail, you might want to think about it. All right?
Your Honor, so you revoked on count 1, you did 2,000, count 2, you did 200? Thank you.
Is this Mr. Hayes?
Yes, ma'am. Antonio Haynes.
Okay, I had a note that you're being represented by Blake Cheek.
Ma'am?
Have you got a private attorney?
Last I heard, I had Leon Cheek on the case. I had Roger Whedon on the case, but
Right.
then it got put to the public defender's office, which was,
Okay. Did, well, I don't know that he asked that we wait on it. Did he just tell you that, just get through first appearances and he'll work on it later?
I haven't spoke with him in months.
Oh, okay. Well then, how about we just go through it and you get back in touch with him, all right? Do you want the public defender appointed just in case you haven't spoken to him in months and that could be a problem?
Yes, Your Honor, I would ask that you appoint us, being that it's set at, I think the bond is set at 9.
Yeah, because the thing is, if you haven't talked to your lawyer in months, I'm a little bit worried about whether you've been paying him and whether he really is going to stay in the case or not.
It was the public defender's
It
office.
was RCC, Your Honor.
Oh, Yes, okay.
ma'am. I've had Roger Whedon on my case.
Oh, got it.
I got out.
All right, so he's already appointed.
With RCC, yes.
All right, and so I still call him Judge Cheek because he used to be a judge. So let's leave him on the case. He's going to be fine.
The judge.
All right.
There's no way I can.
No, and you don't want to say anything about your case because you're at risk of accidentally incriminating yourself. I'm sorry, but Mr. Haynes, you got a lot of stuff going on here. So, let's see. You've got case number 2018 CF 1291380, Division 10, with Judge Mark Blackman, which has a failure to appear bond of no bond on an aggravated stalking charge. And I can't change that anyway, so you might as well wait for Mr. Cheek to deal with that.
Your Honor, he's also a violent felony offender of special concern.
Okay.
But I just don't understand because this is the first time I ever been arrested in this county, and they put the violent felony offender on the plea, and I signed the plea just to get out because my mom broke her knee in 3 places. And the victim.
Sir, you need to be really careful about talking. I mean, you've got too much going on. I'm looking for the violation of probation paperwork. Was there some on that? No? Is it just the one? But he's also on probation.
Yes.
And,
He also qualifies under anti-murder, Your Honor. There's a lot going on.
what? Should I be finding violation of probation paperwork in here? Just the one case?
Yes, Your Honor.
All right, plus, if you're on probation, sir, they're going to file a warrant pretty soon. I think or this is the one he's, all right, this might have originated as a VOP. You need to talk to Mr. Cheek about it, all right? Good luck. You're welcome. Mr. Hemphill? Yeah, okay. I'm having trouble hearing you. Let's see, sir, we have case number 21CF52726, and it is something in addition to what you might be already in here for. If you want a public defender, we can probably appoint one. Do you have a public defender on the other case you're in here on? Okay, so we're going to appoint a public defender, but this new one, going to Division 20, it was in relation to a grand theft motor vehicle, which was the subject of a warrant signed by Judge Alvaro. And I actually did not get the report, which the judge reacted to. He set bond at $2,500. And if you want to know the details of the allegations in regard to the warrant affidavit, it's online, and it should be public information for you to be able to get.
Your
It's
Honor.
just in addition to the one you've got now.
Can the state request no contact with the victim or witnesses?
No contact with the victim or witnesses, okay? If you know who those are. Good luck. Marvin Hill? Yes. Thank you, sir. All right, we have case number 2021-CF5765. It's going to Division 17. Judge Alvaro will appoint the public defender on that. That's the new one. It appears they have enough information to file a charge of possession of methamphetamine with a bond amount of $1,500 and count 2, resisting without violence, bond amount 100. And then another case is case number 2021-CF4495AO, and that you might have been out on bond for. You already had the public defender in Division 22 in regard to possession of methamphetamine. The bond at that time was $500. Let's just double that bond, revoke and double it to $1,000. Sir, get out, make sure you come to court. You're going to have multiple court dates in regard to the two cases. Alternatively, might seek a little drug treatment in the jail while you're here. Mr. Jefferson?
Yes, ma'am.
Okay, thank you, sir. We have a new case, 2021-CF5716, that we can appoint the public defender for. It's in Division 15 with Judge Wilson, and it appears that they have enough information for filing the charge of possession of firearm by convicted felon. They have tacked on a bunch of ammunition charges. The states want to say something?
Yes, Your Honor. I believe the affidavit's a little slim regarding the possession of ammunition by convicted felon. I was just asking for 24 hours to obtain additional information regarding those charges.
Okay. It doesn't hurt anything because he's got a hold anyway because he's out on bond or something similar.
Yes, Your Honor.
Case number 2002-1CF1942. It's in Division 22, and the public defender's already appointed on that. There might be more than one reason to look this over, sir, because of the number of charges that they put on there.
Yes, Your Honor. Are you going to stay the bonds until tomorrow?
Yeah, we're going to look at it tomorrow, sir, and get a little more accurate about the whole situation. I want to hold on for this for a second. We're going to call you back tomorrow. And we'll leave the hold on there, but we'll just recall it tomorrow. Is that okay? You got that? Leave the hold on the out on bond. Can I just hold on to it for a minute? Thanks. All right. All right, we'll see you tomorrow. Okay. Mr. Kirkpatrick?
Yes, ma'am.
Right, okay, thank you. We have case number 2021 CF 5774AO, alleged possession of methamphetamine. We can appoint the public defender. It's going.
Ma'am,
You might want to talk to your lawyer first before you talk to me because you might accidentally admit something.
Okay, thank you, Your Honor.
Okay, sir, it looks like they have enough, at least file it, the bond amount being $1,000. He's had one failure to appear, but, you know, that might be enough for now. Just keep in touch with your lawyers, sir. Mr. Colemansberger? Yes, sir.
Oh, I'm sorry, on that last case, Your Honor, did you appoint a public defender? I didn't hear.
Yes, I intended to. Thank you, though. All right, so, sir, we have a new case, 2021 CF 5776AO. We can appoint the public defender on that. The allegation is possession of methamphetamine. They have enough information to at least file it. With the bond amount of $1,000 and possession of cannabis, the bond amount of $250, find a probable cause. And also, there is a case for which you would have been out on bond, which was 2002 MM 2597AO. The bond was $700 on that, and I'm looking to see if you, not sure I can see if you already had the public defender on that. You didn't have the PD?
So what?
No, Your Honor.
You don't remember, well, okay, so that one was a trespass and carrying concealed weapon and possession of cannabis case. That supposedly you have a court date, May 19th.
May 19th.
Yes, Your Honor, for arraignment.
What's the state recommending or asking for on the old one?
Your Honor, the state would just ask that you revoke and double.
Okay. So,
What is revoke and double?
well, so, no, double means just double the bond instead of revoking it totally. I have some paperwork here in regard to it being a $700 bond, but there's 3 counts. Does the clerk have the breakdown on that?
Your Honor, it was,
It was 500 on the trespass, 100 on the carrying, conceal, and the possession charge.
On each, okay, got it. All right. All right, sir, if we double those, we're going to end up with 1,000 on the trespass, 200 on the possession, 200 on the second possession. And that's pretty standard, and at least it's better than revoking it altogether. So you'll have more than one court date, you'll have felony, and you'll have misdemeanor, and the misdemeanor court date is coming up on the 19th. So be careful about that. You got the public defender on both now. All right?
So if I bond out, I can bond out and shit?
You can bond out, but you have court dates. If you miss a court date, you probably won't be able to get out at all. Okay. All right, Mr. Lee? We have case number 2002-1CF5777AO, an alleged grand theft of motor vehicle that's going to Division 12. Sir, I'm not seeing a public defender form. Were you wanting to get a public defender?
Yeah,
You were?
yeah.
Okay, if they give you a form, go ahead and fill it out. I'll go ahead and provisionally appoint the public defender now. And it appears that they have enough information to at least file the charge. The bond amount is $1,000. If you bond out, make sure you come to court and also talk to your public defender. We'll give you the phone number and the address for your convenience to contact your lawyer.
Your Honor, I'd also ask for no contact with the victim or witnesses.
All right, no contact with the alleged victim. And we have that Emmanuel Love bonded out, so we can pass that case. Is this Mr. Mason? Thank you, sir. Okay, we have two things. We have the new case, 2002-1CF576180, which is out of Division 12. Judge Calderon, and will appoint the public defender on that. And it appears they have enough information to file that. Bond is $1,000. Perhaps a bigger problem is a Polk County warrant, which is a violation of probation on a grand theft charge. That's currently at no bond, and I don't have any jurisdiction to help you on that.
I'm actually not on probation, so I don't even know where that came from.
Okay, well, it's in the teletype.
So that's my problem right now. I would have bonded out, but I'm not on probation, so I don't understand how I have a BOP hold.
Were you ever on probation?
That was about a year ago when I was on probation. I served that time. I did that already, so I don't even understand how that's popping up.
Okay, I don't have the ability at the moment to try to look that up. I think, and I don't know if Polk County is online. I know that in a lot of the clerk's offices, you can actually get online, look up the public records, and print out from your phone practically if a VOP had gotten dropped. Certainly, if I knew that, I would react to it, but the only thing that the jail has right now is that it's still on there. Is there a way that you can just double check that, or? All right, we'll double check that. I'll sign the orders at no bond provisional in regard to, if they find out otherwise, they're gonna give me a different piece of paper, okay? Now, so if you stay at no bond, then likely what happened was they checked. And you might want to follow up or have a family member follow up if they think that they've got the documentation.
I already did that. Just look on me on it. I already did that, and
All right, well,
that literally was like a year and a half ago.
okay, so I hear what you're saying, but, been doing this for about over 40 years now, not all the judging time, but, lawyering and judging. And I need to see the piece of paper. I need to see the thing on the screen, because there's a healthy percentage of the time when somebody thinks a case got dropped or it's finished, that it actually didn't, but they thought it was. So I have to see the paperwork in order to do anything in regard to changing that no bond status.
Your Honor, on the 5761, can the state request a no contact with the victim?
Okay, so ordered. All right, and, is that something you can look up fast? Because he's sitting there, but I think the correctional officers would prefer that the line keep going.
There's only like 3 people left in line.
Say, nobody can look it up for you?
Oh, I had my people look it up already, man. That's what I'm saying. My people looked it up, and I'm not on probation over there.
All right.
So that's what I mean, with all
So-
due respect, I mean, if we could just like maybe look it up quickly or.
I don't know, they're trying.
I know, no, I'm saying because you.
She hasn't told me that she can't.
Your Honor, I believe this should be addressed in front of Judge Lattimore, who's the VOP judge.
Well, can you tell, you can see that he's on probation?
Well, we don't have access.
Oh, no, I wouldn't, do they even do anything without a county VOPs?
Oh.
I mean, he's just telling me the whole thing went away and,
And CCIS, it does show that it was closed.
That's what I'm seeing too. I don't see anything else.
And the last action on the case was October 13th of 2020. I guess he got sentenced, the sentencing guidelines. Yeah, that's all I'm saying. I don't have, I can print it.
does the state have access to out-of-county records?
No, Your Honor, I'm on, what is this, Polk's?
You're looking up
Website?
the Polk website.
Yes, Your Honor.
All right, I'll give you a chance to look at what they're printing out and also to respond.
I don't know if I can print. No, I'm not saying where I can print the screen.
You want me to come over there?
Yeah,
Okay, if you don't mind.
this is the case.
Don't be pushing it around, because I can't. Right. Let's see. What the heck? You're looking at that one?
Yes, the 2019
Just says
CF
closed.
4418.
Oh, I don't know. 2019.
Yeah, you just gotta keep scrolling.
What does it say? Is this, oh.
So this is the BOP case, so you keep scrolling down.
See, you just have docket notes. You don't have the minutes or be in the website. Can't see the documents. What I can see is, the state line anything?
Your Honor, I see on March 6th of 2020, there was an affidavit of violation of probation / community control.
Right, he supposedly, he says he pled out in October, and what we don't have is the documents. We just have a list of like what happened in court, but it isn't even conclusive. It talks about sentencing guidelines. It doesn't say
I
sentence, it does say costs.
I saw his score sheet, and I believe that he was entitled to a PSI. I think that's on there. But I don't see anything one way or the other. I do see the March 6th affidavit for violation of probation.
Yeah, we
I
know he
can't
got
open it.
arrested. He got arrested probably over here and sent over there, and something happened in October, but
I
we're
can't
not
tell.
sure.
I just asked that he be sent back to Lake or Polk, where this can be addressed.
Well, I mean, if the case is closed, then why would I be getting sent back there, is what I'm asking.
Well, here's the problem. We don't have,
But it shouldn't be a warrant if it's not a case.
so, sir, this is really confusing, and I'm sorry, but some clerks' offices are fully digital. For example, if it was a case in Orange County, you'd be able to look it up on your phone. We would have found it because they scan the court dispositions and we could see them. Some counties, they're not fully digital. I've just had a person from the jail staff and the state attorneys looking for it. I don't know if the public defender's trying to look for it too, because she's got her face in her computer, so she's probably trying to find it. But I need to see the piece of paper because the notes, all we have is like docket notes. We don't have the piece of paper. And that's a problem I can't control from here. I can't deal with Polk County. I don't have any jurisdiction. And it may well be that they left something on teletype. It's not conclusive. I cannot conclude from what I've gotten so far that you were sentenced and subsequently released, because there is an equally possible conclusion that they did a PSI, they had the score sheet, but they didn't finish it, and that maybe you were supposed to come back and you forgot. I don't know which of those circumstances existed. Both of those circumstances are consistent with what you're telling me in my experience, because there's a significant percentage of the time, if a guy gets let out because they're going to do a PSI, but they tell him to come back, at least 20% of the time, the guy thinks that they let him out because he's done. And that would be a very normal assumption. I tend, I want to give you the benefit of the doubt, but I don't have the clear information that I need. So I'm going to have to let you,
I mean, is there a way that I can,
yeah, if you got anybody who can get that document from Polk County, I'll be happy to look at it. I'm going to be sitting here for another week and a half, and the jail people will look at it too. They'll bring it right to me, and then I'll reverse the order. If I see the piece of paper, okay? And then, is that something, could you, have somebody call them?
Oh, we already were in contact with Polk County. That's why the hold was placed, that we send a teletype to them saying that the subject is here, he has locals, a hold has been placed. And they already sent back a teletype saying, thank you, TTY received. Please advise when locals are finished. So they want you. They're not saying that the warrant isn't,
Well, that's not 100% conclusive. It's likely that maybe some is still hanging out there and they want you back.
I don't even be in
All right, well, sir, I can't do anything more to help you right now. If somebody dropped the ball over there and they didn't do it right, then you might have some other avenues of redress, but right now I can't help you. So I'm gonna have to stay the no bond hold on you. We've done everything we could do today. If you get somebody with a document in hand, have them bring it to the jail, and I'll certainly look at it. Good luck. Okay, Ms. McCall?
Hello, how you doing, Your Honor?
Okay, I am doing okay, thank you very much. We have you got arrested on, it looks like a warrant in regard to case number 1992.
Yes, ma'am.
And 12960, Division 11, they put it at no bond on a sale and delivery of cocaine. Probably all the witnesses have died.
Oh, ma'am. Oh,
Sorry. And you obviously haven't had a lot of police contact in the last 30 years.
can I say something, Your Honor?
To tell your public defender, it's safer. Gosh, she's probably in high school when this allegedly happened. Uh, and she hadn't even gotten a speeding ticket in the meantime because they would have found us. State, I'm fixing to give her a bond. I don't think you guys will be able to pull this case together after 30 years.
Not all the officers are no longer working at the agency,
Oh,
Your Honor. Some of them
okay.
still work there.
Really? Yeah, no, that's true. Somebody might be my age.
Some of them still work there.
They should have retired by now.
I think 2 of my 4 officers still work there.
That's true. I've seen some of their names on police reports since I've been over here this week. I can't believe they're still working. They must be double dipping on their pension or something.
Your Honor, currently, my client is in DLC, so it wouldn't matter at this point.
Oh, really? Okay.
About the bond amount, however, she would like to, address the court.
I came in 2018 when I got in trouble with the case that I'm in prison on, ma'am, in Broward County. They had a hold on me, and my lawyer let me know. So I came to Orlando, Florida, because my daughter purchased a home up here. And I came to surrender myself, but they said it was not an active warrant, and I had the paper where they said they had a warrant for me in Fort Lauderdale courthouse. But they said they still didn't want me. So probably about a month or so, this hold came up while I'm in DOC serving time.
Okay, so you want to get this thing out of the way because it's messing you up for any good and gain time, right?
Yes, ma'am.
All right, well, just be patient. I can't fix it at the moment. All I got is like a little face sheet. And what you have probably to do is to go through 1 or 2 hearings and before the state figures out if it can produce the witnesses or not after 30 years. And, you know, maybe you get lucky, but you do need to get the thing resolved because it will mess you up on your good and gain time in DOC. So
Yes, ma'am.
might as well-
You're right about that.
yeah, no, you need to get rid of it, but I can't get rid of it right now. I don't have the magic wand for that. You're gonna have
Yes,
to go through
ma'am.
the process. Okay,
Can she give me?
so I'll leave it. It doesn't matter what the bond is because she's stuck with the DOC
Yes,
anyway.
I just wanted to make sure, did you appoint us?
Yeah, let's do that.
Thank you.
You're welcome. Good luck, ma'am.
So, Your Honor, you left it at 0?
Yeah, because it's academic. All right, our next one is 2021 CF 5749AO. This is Mr. Handel Newell? Okay, thank you, sir. It's going to Division 19. I'm not seeing a public defender form, but I think you probably need one.
I believe he is represented on the other case, the capital case, Your Honor.
Okay, by the public defender already?
I believe so.
Let's appoint the public defender on this one.
No, Your Honor, he is represented by private counsel on the 20 CF 273, that capital case. He is private counsel, Alexis Carter. The state would ask that you appoint a PD to see if Mr. Carter wants to pick up this case.
Okay, appoint the public defender. If Alexis Carter is a conflict counsel, they can get appointed on this. If they're private counsel, then they can substitute a notice of appearance. So, sir, they have enough information to at least file the charge. It came in at no bond, and we don't have any witness in here. My guess is that he might be entitled to a bond. Is there any recommendation?
Yes, Your Honor, he is entitled to a bond. It is an F3. This case is ancillary to his capital case.
Right.
The alleged witness tampering has to do with some of the witnesses to that capital case. So I
Right.
just asked for a bond that is reasonable, but also in keeping with that he is, I believe, setting no bond on that capital case.
Let's just set it at 5,000. And it's just getting tacked on to the other one.
Your Honor, the state would also ask for no contact with victims and witnesses.
Excuse me, what is the charge?
Basically, talking to witnesses, and you shouldn't do that. It's, you might want to talk to your lawyer about it, but I'm going to order you not to talk to the witnesses anymore and give you another bond and talk to your lawyer about the details. All right? It's really not safe for you to talk about the case right now. Right, good luck. Is this Mr. Newman?
Yes, ma'am.
All right, thank you, sir. This is case number 2021 CF 4775 AO. It's going to Division 14, Judge Strobridge. And we can appoint the public defender. It was an arrest warrant in regard to 3 counts of alleged video voyeurism. You probably know what it is. I don't know if you want me to talk about it.
Yes, ma'am. I'm aware.
Okay. And this one came in at no bond also.
Yes, Your Honor. I believe he is entitled to bond on all 3 charges. So state would just request a reasonable bond, taking into account the first count, the victim is a 15-year-old girl. The second count, I believe it's a 13-year-old, and the fourth count is another 13-year-old. So I just ask that you take into account that they're sexual in nature and involving children when setting a bond.
Let's see. He has no prior history.
I would just ask that you take that into consideration. The fact that he has no prior criminal history, I'd ask that you consider that when setting the bond amount.
Your Honor, according to the affidavit, Mr. Newman cut out holes in a backpack to be able to angle his phone.
He did what?
Cut holes in a backpack to be able to angle his phone, to be able to
Take pictures, sort of.
Take pictures and videos of the young girl's underwear and private body parts that are generally concealed from view. I understand that he has no history to this point. However, I would argue that this is an extreme violation of these young girls' privacy, and given their ages, I would just like you to take that into account.
Okay. Well. All right, Mr. Newman, and it appears he's been gainfully employed for a while. So I'm not really sure what the felony judges will do with this. But, sir, we'll find probable cause. Like I said, appoint the public defender, but although you're gainfully employed, or maybe you were gainfully employed, you put 0 down, maybe you're thinking you're going to lose your job, I'm not sure. You think?
I believe so. I've actually been in jail since May 3rd in Coleman County. And since then, you know, it's already really changed my life for the better. And I recommitted my life and gave my
Be
heart.
careful about saying anything about the charge, okay?
Okay, I'm not. Yeah, and just like she said, I have no prior offenses, and I think I have plenty of people that would vouch for my character. And
Okay.
if I do get out on bond,
You'll probably have a chance for that, you know. So what has this gentleman been in jail for since May? Because he's just being subject to the first appearance on this, and as far as I know, I don't know of any prior history. Is there something else that he's in jail on?
No, he's probably, they probably, since it was a warrant out, they got him out of Alabama
correct?
and probably just transported him here.
Correct.
So as soon as he got here, he was set.
So
Yeah.
he was stuck in Alabama until he got transported.
Correct.
Oh, wow. Okay. So, because that's where you live, is Alabama?
Correct. And these
All
are
right.
just allegations. I don't believe there's been any evidence brought.
Well, don't
forward.
be saying anything about your case. All right.
Yes, sir, or ma'am, sorry.
All right. Okay. All right.
Can I ask one more question?
Don't say anything about the facts of your case. I'm trying to deal with things like you live out of state. I need to protect the bondsman in case they have to get,
That's,
up there and come bring you back. But also keeping in mind that you don't have any priors, but also this, state's concern about the circumstances is also warranted. So you could say what you want.
What I was going to say is that I would be willing to wear an ankle bracelet if you would release me to go back to Alabama, but I don't know
Right.
if that would allow me to leave the state or not.
Yeah, we had some trouble with that a few years back, and so we don't even do it anymore because we found out they weren't actually monitoring the situation, so we gave up on that.
Okay, all right.
So I'm just stuck with whatever is it going to take to make sure that if a bondsman bonds you out, that they'll be able to bring you back.
Yes.
And because you're out of state. So I think what I'm going to do is let's go with 6,000 per count. In case that bondsman has to get in a van and go up there and drag you back, I don't, I think they ought to be protected on that.
Yes, ma'am.
All right, so obviously you have some court dates. We have the public defender appointed. If you get a private attorney, because things turn around and you get gainfully employed again, feel free to have them substitute out with a public defender. In the meantime, you'll have their address and phone number, can communicate, and you are required to come back to your court dates.
Yes, ma'am.
Your Honor, state would request no contact with the victims or witnesses, no return to the Mall of Millennia, and no contact with any minors under the age of 18 unsupervised.
So ordered. Those are standards, sir.
Yes, ma'am. Thank you.
You're welcome. Mr. Nieves Rodriguez,
Yes, ma'am.
sir, thank you very much.
You're welcome.
We have some new charges, and small charges. Let's see, the new is 2021 CF 5770AO, which is a driving while license suspended on a 5-year revocation. Will appoint the public defender. It's going to Division 15. And it appears they have enough information to file that charge. We'll stay the bond at 1,000 on that. Was it 2,500? Paper on the front, that, what'd they do, adjust it because of the HTO? It really just depends on, what is wrong with his license, but I don't have that information in front of me. I have a conclusory allegation, so it's not significant. Let's see. You have out on bond for case number 2002-1 CF 111380 involving charges of possession of fentanyl, possession of MDMA, possession of drug paraphernalia, battery, domestic. With a return date of June 15th, you already have a public defender, it's in Division 10. And that one, he had, the total bond amount, I think, was 2,500 on that?
Your Honor, yes, it came in possession of fentanyl with 1,000.
And then he got ROR?
The BAT DV was 500, and then the possession of meth was 1,000, but we ended up filing, in addition to those, the drug paraphernalia.
You filed more charges?
Yes, it came in with 3 charges, we filed 4.
Okay. All right, so he was at 1,000 on the methamphetamine, 500 on the battery, and I didn't get the,
1,000 on the fentanyl.
okay. And you filed paraphernalia also?
Yes, Your Honor.
All right. Now, I used to be able to see the driver's license records on these. So how about, since I don't have that, I'll leave it at my original $1,000 bond on the driving license suspended. But, sir, it is a violation of release conditions to get a new law violation while you're out on bond. I don't know how bad this is. It's not like, I wish I knew more about the driving record. But I expect the felony judge expects something to happen on that. Let me double the bond on count, whatever count 1 is now, possession of fentanyl, to 2,000.
Count 1 is the fentanyl.
Okay,
Count 2 is the meth.
yeah, I get it. Count 3 is the paraphernalia, and count 4 is the battery.
Yes, Your Honor.
Your Honor, I would just ask that given it is a driving offense, that you not double all of the bond amounts in this.
That's what I was saying, but the problem is I can't, if I don't have that driving record, I don't know if it's just a real minimal situation. It's called a HTO, but some of those HTOs are on, payable offenses that they didn't even go to court for. So since I don't have really good information, there's no crash, it doesn't seem to be anything aggravated. Let me double it on count 1, revoke and double it on count 1, leave the other ones the way they are. Just send them downtown and let them figure it out. Now, sir, you basically got a good deal here. You got 2 different court dates, you got the public defender. You can't, if you commit any more crimes, you just probably be no bonded. I don't want to encourage you to think that it is easy.
So what's the bond amount? What was it before?
So on
The
count
meth is
1,
gonna
count 1, I just doubled it to 2,000.
Mhm.
And
So
the other ones
22.
the other ones I stayed. Count 2 was 1,000. Count 3,
500.
there wasn't any. Oh, now we got the driving record. Well, he's gone. Okay. Yeah, it looks like he failed to pay some things.
On the,
It makes a difference, honestly.
on the out on bonds, you're just gonna make possession of fentanyl 2,000?
Correct. And
And then-
stay everything else.
1,000, 500, 500.
Right. 2, 1, oh, wait, well, I didn't put 500 because you didn't, well,
The other one just got charged.
How you doing
the
today,
other
Your
one
Honor?
just got charged. I didn't add 500 on that, okay?
So
Sorry.
paraphernalia, I'll leave
Did
at
you get what I did on that one? Not really.
I missed it.
All right.
That's what you want? I don't know. Just put what you want.
Yeah, no, so he was 500 on the battery, and, I didn't do anything on the paraphernalia, that was added, and I just, you know, I'm gonna call it a ROR, because even though he should be getting credit, I didn't want to add anything at the time, I was concerned that the dwellers was minimal, and I was trying to not, rack him up too much.
Okay, so 2001.
2, 1,
ROR.
ROR, and 5. Yeah.
Okay.
And this is going to be Mr. Noy. So Mr. Nieves Rodriguez is already gone. I'm now looking at, if he was on probation, I think that you noted that also?
Yes, Your Honor, I believe it's juvenile.
Okay, we didn't come in with an on view, so he'll probably get hit with a VOP before he bonds out.
Yes, Your Honor.
All right, so you got him covered. All right, Mr. Noy.
How you doing today, Your Honor?
Okay, thank you.
Yes, ma'am.
We have,
Sorry.
we have some old cases that you're out on bond for. We have a new case from a couple days ago with a new possession of firearm by convicted delinquent charge. That's case number 2002-1 CF 5758. We'll appoint public defender. It's going to Division 17.
Your Honor, state asks that you stay his bond in the 5758 case and revoke with no bond as to his out on bond firearm and third-degree murder cases.
Okay, I understand what you're asking for. Yes, ma'am?
And Your Honor, I would just ask that if you are inclined to revoke, you revoke, and double the bond amount as opposed to holding him at no bond.
Yes.
It clearly there were some concerns. If you look at their arrest affidavit, it does mention Baker acting. I'm not sure my client was in the right state of mind. So I ask that you take all of that into consideration.
No, don't say anything because you're in a heap of trouble.
I'm sorry.
And you're
Yes,
going to
ma'am.
accidentally incriminate yourself
Yes, ma'am.
if you say anything. So just don't, all right?
Your Honor, he has a very significant history, and they're all involve firearm charges.
Yeah,
This
you
one
don't have to
included.
say anymore. Look, son, I'm going to leave you in there and let your public defenders take it downtown. There's just too much going on, and you're just going to have to hold on and try to be patient until you get in front of the judge and have a real hearing. Because, you know, I can't play with guns going off. I just can't.
No gun.
And if you need to get Baker acted, God bless you, do it, you know, because we can't deal with this.
Yes, ma'am. I
So
understand.
don't say anything.
I understand now.
Okay. So I'll find probable cause on the new one, 21 CF 5758, leave it at 5,000. But on the other ones, possession of firearm by convicted delinquent, I guess is 2020 CF 1277180. I think that the judge would require a no bond on that one. And on the 2020 CF 11579 CO, third degree murder, would just revoke it, send it downtown, you all have a full hearing.
So those are both revoked and set at zero?
Yes.
Thank you.
Yeah, don't pay it. I'm not. Because they have to by law.
You have a good day.
You too.
Okay, is this Mr. Pierre? Okay, thank you, sir. This is case number 2021 CF 576380, and it's going to Division 22. We can appoint the public defender.
Your Honor, he does qualify for pretrial release. I see no criminal history.
I didn't hear the last part.
I don't see any criminal history on the sheet.
Okay.
So I would just ask for pretrial release.
State, have any response in regard to that? It includes a firearm charge, so it's more significant.
Yes, Your Honor, state would object to PTR. If you're otherwise inclined to put him on PTR, state would ask for a bond in conjunction with PTR, but would prefer just outright bond. There was drugs with a weapon. I believe there was also a black ski mask found with the weapon. It seems like there potentially were other things going on. So state would object to PTR. I understand that he has no history. However, this is a rather significant offense, given that there was a firearm in conjunction with the drugs as well as the black ski mask. So state would just ask for a bond on both cases.
Don't talk about the facts.
All right, but he straight up qualifies with a gun?
Yes, Your Honor.
Really?
And,
Interesting.
Your Honor, since this is his first offense, I would just ask that you place him on straight pretrial release.
I recognize these young guys, if they're carrying drugs, they think they need to have a gun, but it's just. Really bad accidents waiting to happen. Sir, I'm having a little trouble with that part. Let's find probable cause and,
And Your Honor, just for the court's consideration, the firearm is registered.
to him?
Yes.
Your Honor, he still cannot have a concealed firearm. Why it was concealed if it wasn't registered at the time
All
as
right.
a CWP.
I understand. I just want the court to know that it's not a situation where he just had an illegal firearm, Your Honor.
Okay, all right. Let's do count one, 500 for the possession of cannabis over 20 plus PTR. Count two, 500 for the carrying concealed but registered firearm plus PTR. So you got a little bit of a bond. You do need to understand that some of these facts are going to catch a judge's attention, running around with guns and drugs. It's just a good way to get hurt or get somebody hurt. Follow all the rules on pretrial release. I think they have random urinalysis, which probably won't kill you.
Your Honor, you have to order the random urinalysis. State would ask for no drugs or alcohol without a valid prescription, RUA, and no weapons and firearms.
All right, so ordered.
And Your Honor, I would just ask for that 30-day grace period, given the fact that it is cannabis, before the urinalysis began.
A grace period?
Yes, a 30-day grace period, so he's not violated.
Your Honor, it's typically granted because cannabis stays in your system for upwards of a month.
It's
So-
normally granted, right? Okay. Okay, no problem. Is this Mr. Pope?
No, it's bonded, Your Honor.
Okay, thank you. Mr. Rahman?
He's behaving, Your Honor.
Oh, he's got mental health issues. You want to deal with him later, in a minute?
Yes, Your Honor.
Okay, we'll put him aside. Is this Mr. Spikes? Okay, thank you, sir. Okay, evidently we have an add-on charge for you. It's case number 2021 CF 5768. AO going to Division 14. Do you already have a public defender on your other charge? Oh, I'm sorry, we got a public defender affidavit, and you do qualify for the public defender. The allegation is criminal mischief dated from the 3rd of May. And so I think this is in relation to a computer that might have got damaged or something. It's just on top of some other things that you already got arrested for, which, don't worry if you didn't remember it, probably sounds like we're having a really hard time. Counsel, since this is an add-on, let's just put it as a subsidiary 150. I have a feeling it's just added on to the other charges.
Your Honors, respectfully, state would object to that. It is a new case. The other case was heard weeks ago, and given the nature of the violence of the counts, state would object.
Is this in addition to the other things that are articulated on the affidavit that were the other charges?
Yes, he was seen on those.
Same incident?
Yes, Your Honor.
Okay, so if he all came in on the same one, it would just have been a subsidiary at the time. So I'll put it at 150, sir. It's just an add-on misdemeanor, or maybe it's over 1,000, so they might be filing it as a felony, I don't know. We'll point the public defender. The other thing about it is, the public defender might need to get it put back in the same division, because when they come through separately, they get sent to different judges, so be careful about that.
Yes, ma'am. I was told I was gonna get the regional conflict counsel.
Okay, so that takes a little bit of time because the paperwork kind of has to catch up. You would think it's all digital and we'd have it handled right away, but we don't, for some reason.
Can I know exactly all my charges, please?
Well, I haven't looked them all up, sir. I don't know if you have access to a cell phone or computer, or anybody that you know could, look that up for you and let you know.
It's just the battery and the criminal mischief.
Battery and criminal mischief? Okay. Good luck.
Job is kill. His behavior.
Okay. All right, I'll put that to the side for a moment. Thank you very much. Is this Mr. Tomlin?
Yes, ma'am.
Thank you, sir. All right, sir, we have a new case, I think, is 2021 MM3347AO in regard to an alleged resisting without violence. We could appoint the public defender if you want it. But you also have some old charges. The resisting is going to Division 62. And they have enough information to at least file the charge on that. Bond is normally $500 on that one, wanting the public defender. The old one, I think, is the one that they were trying to arrest you on. That was from 2019. And so there was a zero bond on that because sometimes the judges, that's just what they want. They don't want me to change it. It was a resisting with violence and supposedly a failure to appear November 23rd, and the judge said, leave it at zero, so that's what we'll do. Point the public defender on the new one, and they'll let you know as the cases come in.
Will I be brought out?
No, you can't. The one that was failure to appear, the felony judge put notes on there, don't touch this bond. He needs to come back, you need to come back to that judge. They don't want anybody to let you out, so you got to see that judge. You just got to be patient.
Well, I don't know how long, man.
I don't know off the top of my head. I mean, it,
We don't know.
you know, it's not going to be years. It's going to be weeks before you get in to see the judge, and hopefully you see the public defender before then. But that, you know, some public defenders are better than others at that.
Under stress and depression, man. Taking pills and, defibrillator and all this stuff. So
You're getting too old for this stuff. You can't do this anymore.
I try to be as calm as I can, man.
It is complicated. Life is complicated. Okay, good luck.
So
Yeah, you'll see him sooner or later. Okay. Okay. All right, so, is this Ms. Surratt?
Ma'am.
Okay, thank you. Okay, we are on the felony violations of probation, ma'am, and we're going to appoint the public defender to represent you. It looks like 2 cases, I think. 2018 CF 4113AO was out of Division 14. It came in at no bond in regard to a violation of probation on a grand theft, 3rd degree, and it was alleged that you had failed to complete your drug court treatment program. Judge White had put it at no bond, but as you know, he'll probably bring you into court pretty soon. Then also 2019 CF 14807, similar situation, violation of probation on a false verification of ownership, and it's just the same thing, the drug treatment program, and you need to see Judge Whitehead, but we're appointing the public defender.
Ma'am.
All right. All right. Is this Mr. Warner?
Yes.
Okay, thank you, sir. This is case number 2018 CF 897180, an alleged violation of probation. Did you fill out a public defender form, or were you going to? Because we probably want to appoint the public defender even if you didn't fill out a form, because unless you're getting a private attorney.
I have a private attorney.
He stated he has a private attorney, Your Honor.
So we're okay with that? All right, so it probably won't hurt you too bad because you'll be seeing the VOP judge pretty soon anyway. Sometimes we worry about it because people think they're getting a lawyer, but nobody paid for the lawyer, and then they end up in court, they don't have a lawyer, and that's a problem for everybody. So it just slows everything down. But I think we can wait on this one. I guess you got put on felony probation for unauthorized use or possession of driver's license or ID. And then you were alleged to have violated probation by getting arrested on November 2nd for resisting an officer without violence and battery. The felony judges usually no bond you on this one. It's going to Division 20. And so that's what I need to leave it at. I don't touch those. They don't, they just do no bond on the felony VOP. So if you don't have a lawyer when you get in there, they'll probably give you one right away. Good luck. Okay. Mr. Arthur?
Yes, ma'am.
Thank you, sir. You have an out-of-county warrant in regard to obtaining goods by use of fictitious name or credit, or if I counterfeit credit device and unauthorized possession of driver's license. It's, where is it? Volusia. And it was from November. Judge Foxman, what's the bond on that? Oh, I think he's got it at no bond. So, sir, they'll come pick you up soon. I can't do anything with that bond. It's not my jurisdiction. But they'll give you a ride over there. Okay? Is this Mr. Corbett?
Yes, yes, ma'am.
Okay, no problem. All right, so we have an out-of-county warrant on, probably failure to appear for some competency status hearings. As well as an open case out on bond in Orange County. These are. Right. If you're all okay, I'll go in the back and look at the out-of-county warrants first. So the out-of-county failure to appear arraignment for no motor vehicle registration. The bond amount is $263, and that's from Seminole County. Judge Woodard. Probably coincidentally, the amount of court costs it would cost if you pled. And while you were out on bond for 2020 CF 14820 for possession of methamphetamine and controlled substance.
Your Honor, I would just ask that because there is competency issues, that you take no action on the out-on bond case.
Yeah, well,
There is no suggestion of incompetency filed, Your Honor.
There is.
I have nothing in 20 CF 14820.
it was in one case or two, well,
It's in more than one.
well, yeah, it's coming up on the first appearance detainer notes.
I have it in 2160 and 9610, but
Right.
nothing in 14820.
Right. So there's been an issue.
Your Honor, normally when it comes in, it looks like they have it listed, even in our system, as incompetent to proceed. I think it's a matter of filing the
A matter of what? I'm having trouble hearing you.
filing the document with the court to get it transferred over to this new case, but it's clear that there is competency issues in more than one case, and because of that, I would ask that you take no action on the out on bond.
Right, well, the other problem is that this other thing is just, it's really small. On a no motor vehicle registration, you know, the judge wrote the $263 amount. He's just trying to clear the case. He's not
Yes.
really worried. So, with all due respect, I'm not going to take action on the out on bond. But sir, Seminole County wants you on a failure to appear for a no motor vehicle registration case. You understand what I'm saying?
Yes, ma'am.
They'll probably drive you on over there unless you bond out on it. And other problem is you're getting more cases than you probably can keep up with right now.
Yes.
Hopefully you have somebody helping you out.
Yes, ma'am.
All right, good luck. Okay,
They didn't drop it
okay, thank you.
after we looked at it.
Is this Ms. Newman?
Yes, ma'am.
All right.
Denise Newman, sorry.
Let's see what we got here.
Ma'am, if I could speak for a second?
You might want to talk to the public defender first because you're at high risk of accidentally incriminating yourself. It is my experience. I mean, I'm not looking at your case and making that decision. It's just that it's almost 50% chance that you're going to incriminate yourself if you start talking, in my experience. Plus, you got a bunch of out-of-county warrants. one where your paperwork would help me see what's really on here. Because you have it listed, and here I have to go through the individual pages and like decipher the stuff. So that's why it takes me a while.
Thank you.
Because I don't have it just listed out like it is on yours. In fact, okay. All right, ma'am. Ms. Newman, I can't really help you on this because these out-of-county warrants, I don't have jurisdiction over in Seminole County. So you basically have to go deal with it over there. Okay?
I went to court on Monday. No?
I mean, if she can look something up, fine, but it's Monday, yesterday?
Yeah, on Monday at 8:30, I went to court with Lewis on the 12th floor, and he gave me to September to come and bring all the proof.
Oh, do you have any paperwork with you?
It's in the system. I was there
Right,
at
well-
8:30 on Judge Lewis.
Your Honor,
It's
it's Judge Calderon.
yeah.
She had arraignment on her out on bond case, the fraud use of personal ID.
The one that's local?
Yes.
Okay. Well, these are Seminole County cases, ma'am.
Because I was on home confinement through Seminole County for the same charge that my sister filed. I was on home confinement for that ID that my sister said that use of ID. I have my ID. I have my own place. I'm just saying, she said.
I would not.
Okay.
Your Honor.
Right, it's, I can't deal with it from here.
Oh, what will happen now, ma'am?
Well, here's what'll happen. It looks like you were on probation for some things, and I am having trouble getting all the case numbers.
I can tell you
Maybe
what.
somebody can fill that in for me from Seminole County, but one of them, the first one, is an alleged violation of probation do you have the paperwork? Can I just read it off of yours? This is.
17 CF 901.
I've got some very different looking stuff than probably what you have, but, on the front? These? This? 21 WA 1657? That's what the case number is in Seminole County? Okay. All right, that's a warrant on a violation of probation for grand theft, and it's sitting at no bond. I'm sorry, ma'am, that I don't have the details about these individual allegations of violation of probation. There's supposedly another case number of 21 WA.
Yeah, that was in March. That recently
Same
was a
one.
KPS.
All right, is there? There, okay. 21 WA 1659 is a warrant for no bond on a VOP for criminal use of personal ID. That's at no bond. Then 21 WA 16, that's a duplicate of the 1659. There's another one, 21 WA 1656, out-of-county warrant, no bond for failure to, violation of probation for failure to redeliver hired vehicle. And 21 WA 1655, out-of-county warrant, no bond for VOP on possession of cocaine. 1659 is that the last one, or is it a duplicate? He did an unarrest? Just used another affidavit. Okay. So, ma'am, let's take no action on the one that you saw Judge Calderon on the other day, because he may or may not have known about all these warrants anyway, and he's got you coming back.
It disappeared because it violated my probation because I was on probation.
All right, so now you got the violations of probation, and you got to go back and get a public defender over there and get a court date over there and see if they're going to let you out. That's all I can do.
Thank you.
You're welcome. Is this Mr. Owen?
Yeah.
Okay. All right, sir. We have an out-of-county warrant from Lake County. The bond amount is $5,000 on this, 20 mm 6199, in relation to an alleged failure to appear on a trespass. So I think what will happen, sir, is they'll just pick you up and take you over to Lake County, and you can resolve it over there. If you bond out, make sure you come back for your court appearances. Is this Mr. Rose?
Yes, ma'am.
Thank you very much, sir. We have a warrant out of Hillsborough County in regard to a petty theft, failure to appear. The bond amount on that one is $100, sir. If you do bond out on that, you'll be provided a court date. And I'm having trouble making these case numbers out for the other counties.
Excuse me, Your Honor.
So there's a public defender affidavit. Is there a local case, or is it just the out-of-county warrants that we have? Just the out-of-county warrants that we have, right? Okay. That's all we have. It looks like a $100 bond for you on Hillsborough County.
Yes, Your Honor.
Is it set 1,000? Did you, 100? Okay, yeah. It's unusual, but it's a small bond. They just want you to come back to court.
Oh, yes, ma'am.
All right.
I was actually going to ask, I got picked up by officers in Orange County and over at the hospital. I had gotten notice of my friend being shot, Christopher. I was going to check up on him, and that's when I got stopped by the police. I'm homeless already. I was late to a job interview. I was on my way to go get another job, a second
Sir,
job.
I can't change a warrant from Hillsborough County.
Oh, no, ma'am. I was just giving a reason why I got a.
It's all right. I'm all full with reasons today. I've heard a bunch of them already,
Oh, yes, ma'am.
but I wish you good luck on that.
Okay.
Okay, is this him?
Yes.
Okay. So you got a mess of cases?
Good afternoon, Your Honor. This is Carlos Morales, State Certified Spanish Court Interpreter. The interpreter has not been sworn in yet today.
Really? Good for you. So I guess you get to raise your hand and I get to ask you to be sworn in?
Yes, Your Honor.
Do you swear to faithfully interpret from English to Spanish and Spanish to English, so help you God?
I do.
And
Carlos
that's
Morales, State
from an
Certified.
orally old memory, and the clerk usually does it, so hopefully it's good enough. And nice to hear your voice.
Likewise, thank you, Your Honor.
Thank you. We have Mr. Santiago Chico, I think. Yeah. And we have 3 out-of-county warrants for him. You want me to stop, or? I guess you
Uh,
can't. And we also have,
The-
yeah, first appearance detainers.
Your Honor, just for the court's benefit, the interpreter is doing a simultaneous interpretation through the headsets.
Oh, okay, I forgot. Okay, so, sir, you have warrants out of Osceola County. Case number 21CF926. It's like 3 counts. Including possession with intent to deliver cocaine, fentanyl or paraphernalia. Count 1 is at 15,000. Count 2 is at 1,000 with condition of no drugs, alcohol, or other controlled substances without a prescription. Sorry, count 2 is at 15,000 and count 3 is at 1,000, and all of them have that condition. So the total bond on that first case is $31,000. It says 15,000 on here. Let me look again. Yeah, I think,
That's correct. They're F2s. It's possession of cocaine with intent to sell and deliver, and then possession of a controlled substance with intent to sell.
okay, so I've got 2 pieces of paper, but I think there's just 1 case number for the Osceola County,
Yes.
right? And,
1 case number, 3 charges.
right. See, I get the duplicate papers and I have to look through them. Now, we do have some pending charges locally. Do we need to do anything? Because it's hard to tell when these other cases supposedly happened, or did they happen before the local charges or after?
The Osceola case?
It's a pretty high bond anyway.
Yes. I was trying to pull it up, Your Honor. I would ask that you take no action on the out on bond.
Well, if you want me to take action, it would be helpful for me to know if
Yeah, I don't know.
if the Osceola County predated or postdated, because if predated, it's certainly not a violation, and I don't have much information. I don't have anything.
I'm looking at it right now, Your Honor.
Oh, they're all Osceola? How about we just assume that this is just a new charge and he's already bonded out on the other ones, unless you can tell me something to the contrary. Because with these bond amounts, they might have already taken it into consideration.
Your Honor, the $15,000 is what's standard for possession with intent to sell.
Okay.
Looks like
We can tell something from the case numbers.
it looks like the Osceola 21 CF 926
Yeah, then,
occurred March 30th of 2021.
yes. So the other ones are 835, 837, 832, so they might have predated, but
March 23rd.
But we don't know when they might be just adding on charges that, as they do sometimes when they,
Yeah, I can't pull it up. Your Honor, since we don't know, would you mind not taking any action?
yeah, I understand what you're saying. I'm just giving her time to make her argument. Because it looks like they might be just add-on charges, I don't know.
I'm looking at the affidavit.
Yeah?
What'd you say? No.
Your Honor, on the 21 CF 832 case, that happened February 25th of 2020.
Yeah, I think they happened before the other one. But he got arrested on them March 23rd.
Yes, Your Honor. State would request you take no action at this time.
I didn't hear the last part.
State would request that you take no action.
No action, okay. All right. We're assuming that they're finding these charges, they're continuing to add them, and so we're just going to stay the bond on the new, what we think of as the new charges, but they're similar in time with the old charges, but their charges being added on, and we won't take any action on the other ones that you're already out on bond for. And you'll get over to Osceola pretty soon, and I assume you'll have a lawyer appointed on everything, and they can try to put them together. Osceola will come pick you up right away. Good luck to you, sir. Okay, thank you, Mr. Morales. That was all we needed.
Sounds good, Your Honor. Thank you. Have a good afternoon.
You too, thank you. Do we have anything else?
Yeah, you have the.
The resets, Your Honor.
Oh, yeah, the one that we set aside, what was that?
There were two,
And
Teal and
Yeah,
Ryan.
yeah, two people who were not here because of medical or something. At least two. Might be three. It looks like I've got a Rahman and a Teal and a Jefferson. Okay. What do you all want to start with?
Teal.
Thank you. Teal, Jarvis Bernard. If I had notes on it, I've